Hi guys, happy Monday. Hope everybody had a great weekend. Got to do some productive stuff, had a good time, got to relax. So we're going to finally, finally finish up with Love's first plea deal witness, Trontavious Stephens. He originally got on the stand on the 3rd of January. This last day that he's on the stand is the 29th of January. It's going to be day 21. Her direct was incredibly long. That was a good slip. Her redirect was incredibly long. They put in like 2 witnesses in between. They took a holiday break. Just craziness. So we're at the point where Love passes the witness after redirect, and we're going to get a little bit of recross and, of course, some evidentiary arguments from Love. I do want to give a shout out. The first comment on this video is Flesh of the Gods a year ago. He says this guilty plea. He says, well, I'll have to read it to you guys. This guilty plea also makes his testimony unreliable because he is scared the prosecution will put him back in jail. Now, what ended up happening with Munktunk? So there we go. We're going to get into it, you guys. Good morning, FFS, with the bright and early boop. Hey, Angie. It's been good to have you back in the chat. Hey, Gerald. Good morning. Good morning. Hey, Cutthroat Radio. Amanda Robinson. Phoenix is in here. I think Phoenix has been on some replay crew. I appreciate that. Jenny, good morning, and thank you for the super. Jenny says, happy Monday, Kat, and the whole chat. Factual Lie, here bright and, well, afternoony for Factual Lie with the nose wipe. And STS, big thank you, gifting 5 memberships already, supporting this stream. Guys, you are supporting my hunt for, there was a hearing in 2022. It was December 15th. I think that's a critical date for a lot of reasons, because we know a lot of the plea deals, there's a holiday, obviously, Christmas time, courts close down. But right after the holiday, suddenly there's a bunch of plea deals offered and accepted. On December 15th, 2022 is the day that Glanville actually grants Jeffrey Williams, Young Thug's request to suppress key evidence, namely the cell phone that they seized when they arrested him after the May 2015 indictment, which is a critical part of, in my opinion, what they wanted to use to tie Jeffrey Williams to the murder of Donovan Thomas, seeing maybe if they could look at his phone and find leads to go look at other things. But Glanville agreed it was an unlawful seizure, and now there is a fruit of the poisonous tree issue for certain pieces of evidence that were obtained in Glanville's ruling because of this phone that they shouldn't have had in the first place. But I can only find clips from that. But that's what I want to watch tomorrow. I think that's a critical piece of why we got so many plea deals December 27th, 8th, 29th. So I thought that'd be good to round out our first plea deal witness. So big thank you to STS. He's going to be sponsoring that continued search. I'll keep looking for it. If not, we'll make do with some articles and some clips. And good morning to everyone. I hope everyone is doing super, super, super well and is ready for a week ahead. And Flesh of the Gods, we just saw you in the throwback chat over here on YouTube. Good morning to Monique and Slat from Amber Dawn, and hey to Jennifer. Guys, you know the drill. Let me know if the volume is good or if you want it higher, lower. Let's see.
All right, any redirect, Mr. Sharp? Or recross, I'm sorry. Go ahead, sir.
Mr. Stephens, good morning again. I'm going to ask you a little bit about the agreement, the plea agreement that you had with the state. Would it help you if you have that agreement in front of you?
Yeah.
Your Honor, may I approach?
You may, sir.
And for the record, I'm handing Mr. Stephens State's Exhibit 16U, okay? Okay, Mr. Stephens, we just watched a video of you entering your plea on this case, correct?
Yes.
Okay, and that occurred on December 29th of 2022, is that correct?
Yes.
Okay. I want to talk to you a little bit about December 9th of 2000, or December 29th of 2022. The night before you came into court to enter a plea, where did you sleep?
In the cell?
Was that at Rice Street Jail?
Yes.
Okay, and that's the jail that we asked you about a few weeks ago?
Yes.
Okay. And when you were brought over, did deputies bring you over to court that morning?
Yes.
Okay. And when you ride over to court with the deputies, are you by yourself?
No.
Are you with other inmates?
Yes.
Okay, and deputies, correct?
Yes.
All right, you're not with your family?
No.
You're not transported over with your attorney?
No.
Okay. And once you arrive at court on December 29th of 2022, where do they bring you?
Court?
Okay, do they just bring you directly to the courtroom?
No.
Okay, you're put in a holding cell in the basement of this building, correct?
Yes.
Okay, and how long were you kept in that holding cell in the basement of this building?
Until they ready?
What, do you remember that morning? Was it hours?
No, I don't remember.
You don't remember? Okay. When you're held in the basement of this building, are you in handcuffs?
Yes.
Okay.
No.
No? During transport, are you in handcuffs?
Yeah.
Okay, but they take them off when you're in the holding cell?
Yes.
Okay, in that holding cell in the basement of the building, is there a TV?
No.
Okay. There's concrete benches, right?
No, they metal.
Metal benches?
Yeah.
Okay. And you are held in those holding cells with other inmates waiting to go to court, correct?
Yeah.
Okay. Is your lawyer there?
No.
Okay. Eventually, were you brought up into a holding cell, a holding area for an individual courtroom?
Yes.
Okay. And in that holding cell, is that another cell?
Yes.
Okay. Does that have metal or concrete benches?
Yeah.
Are you in handcuffs when put into that cell?
Yeah, I think handcuffs upstairs.
Okay, handcuffs upstairs. And throughout that whole process of transporting you from the jail to the holding cell in the basement to the holding cell of the courtroom, did you have access to your family at all?
No.
How about your lawyer?
No.
Okay. At some point that morning, did Ms. Gladden, your lawyer, come speak to you in the holding cell for the individual courtroom?
No.
Okay. Did you speak to Ms. Gladden at all before court that day?
No.
Okay. And was that video a video of you in court with Ms. Gladden that day?
Yes.
Okay. When did you initial the factual acknowledgements on your plea agreement? If you recall.
I think it was that day. I think it was that day. I don't know.
On December 29th?
I think so.
If you don't
I don't
recall,
know.
you don't recall.
No.
So is your answer you don't recall?
Okay.
Okay, so you don't recall initially?
Yeah, I know. I initially, yeah.
Okay.
I don't know when. Yeah, it had to be that day. Yeah.
Okay.
I don't know the day, bro. I don't know the day, sir.
Okay, it's okay. So initialing it, do you recall if that happened in the holding cell or in the courtroom?
It ain't happened in the holding cell. It happened in the courtroom.
Okay, just before you took the plea?
Yeah.
Okay, do you remember how long you spoke to Ms. Gladden when you were discussing the factual acknowledgements?
I don't recall that was like a year ago. I don't know the exact detail.
Okay, just to be clear, Mr. Stephens, I'm just asking you if you recall things. If you don't recall, that's fine, okay?
Yeah.
Okay. This form that's in front of you, 16U, though, that was provided by the state, correct?
Yes.
Okay. Now, this plea deal that we're talking about, that's memorialized on 16U, that was between you and the state, correct?
Memorialized?
The plea deal that you you came to agreement with this plea deal. Who did you come to an agreement with?
Yes, the state.
The state. Okay. Did you come to an agreement with me?
No,
Did you come to agreement with any other defense attorneys or defendants?
no.
Okay. To your knowledge, to your understanding, who is the party in this case that can make sentence recommendations?
Objections?
I sustain the objection.
Okay. Who made the recommendations in your case about what was going to happen?
Objection?
Basis.
Relevance? And
Yes.
It goes to motive and bias, Your Honor.
I'm gonna sustain the objection. I think there's another way you can probably ask him that.
Okay. In that video, who was the person that was recommending a sentence to you? Was it Ms. Hilton?
Who read the paper to me?
Who recommended a sentence? Who did you make a deal with? Was it the DAs?
Yeah.
Okay. And they made a recommendation after you initialed this that you would receive 10 to do 2, correct?
Yeah.
Commuted to time served,
Yeah.
which meant you would go home after entering the plea, correct?
Yes.
Followed by 8 years of probation, correct?
Yeah.
Okay. Were any of the defense attorneys even present when you entered this plea?
No.
How about any of the defendants? Were they present when you entered the plea?
No.
To your understanding, do any defense attorneys even have the ability to make a sentencing recommendation to you?
objection, Your Honor.
I sustain the objection.
I asked to his understanding.
I sustain the objection.
Okay. The terms of your plea, Mr. Stephens, if you go to page 4, you there?
Yeah.
Okay, defendants, you see where it says defendant sentencing acknowledgements?
Yes.
Okay, number 2, it says, I understand if I violate any portion of this agreement before, during, or after the initial trial of this case, I am subject to having the entirety of my sentence revoked to prison. Correct?
Yes.
Okay. And number 3 says, I understand that any violation.
Must object as to ask and answer on direct inquiry.
I sustain the objection because you've asked this before. So.
Your Honor, they just played the tape of the plea.
Something else, Mr. Chair.
Okay. What does sentence revoked mean? To revoke your probationary sentence means that they would, or someone would accuse you of breaking or violating your probation, correct? Is that what?
Yeah.
And if your sentence is revoked, that means your probationary sentence. Well, let me back up. When you're on probation, are you in jail?
No.
Are you in prison?
No.
Okay, you're given rules, correct?
Yes.
And one of the rules that you're supposed to follow in this case is you're supposed to testify in accordance with this plea agreement, correct?
Yes.
All right. So if your sentence is revoked, that means your probation is converted to a prison sentence, correct?
Yes.
So the 8 years of probation that you were given would be converted to 8 years in prison, correct?
Yes.
Okay. And the state is the party that can move to revoke your probation, correct?
Yes.
Okay. So the state, as we sit here today,
Has leverage
if
that
they
we do not.
determine that you violated the terms of your agreement, can move to revoke your probation.
Objection, ask and answer.
I sustain the question.
Okay. When someone moves to have your probation revoked, a warrant is issued and you go back to Rice Street, correct?
Objection, Your Honor. Ask and answer.
I sustain the objection.
That has not been asked and answered, Your Honor.
Yes, it has. So,
Okay.
or I'm going to sustain on another ground. So on independent grounds. So.
Okay. Your Honor, a juror has a question.
Oh. Ladies and gentlemen, let's take 15 minutes, please. All right, take a comfort break. We'll see how the day leads us from there. We're in recess.
So this is the link to the December 15th, 2022 hearing that I wanted to play. I think they took it down because apparently it was somebody got on the court Zoom naked and was showing their junk and yelling "Free Young Thug." So we won't be able to watch that. I'll keep looking for a different stream of it. But in short, you guys, as described at the beginning of this stream, December 15th, like a week before, these plea deals seem to be going across people's tables. Key evidence was suppressed. Glanville actually granted Jeffrey Williams, Brian Steele's, and Keith Adams' request to suppress key evidence. And then suddenly we get a bunch of pleas, including one that Tick ended up signing a week or two later. So I'm just telling, in my head, like piecing all of this together, it's a lot to follow, but I see the big picture. I've painted the big picture based on what I had available in front of me. That's the way I imagine the entire timeline going. Also, shout out to Flesh of the Gods out here sniping. He said, "You're a slime," and "You're a slime." So we've got to get you in the banner here. Let's see. Flesh of the Gods is like, "I still think this plea deal is crazy. It's just leverage. It makes them unreliable." And I think Shart is doing a great job. He's taking a similar approach, laying out the characteristics, things that would deprive you of your freedom, the little teeny details, and really help you visualize why you're not in control of your own destiny when you're in a situation like this. But he's doing it in a slightly different manner. He's drawing the contrast rather than just saying you would say anything to get out of there. He's adding in this layer of, I know Miss Love was asking about your 10 to 13-minute conversation with Brian Steele, with Jeffrey Williams' counsel, and how you didn't talk to the state. You didn't want to talk to the state. But they're the ones that have the power, right? We don't have that leverage over you, and I think that's really effective. So again, I will keep looking. What I will do, since I can't find this, I'm going to drop Flesh of the Gods channel link in the chat. Tons of archived content. Make sure you check them out. Show them some love.
Mr. Stephens, you step up.
Ooh, that's super jingly.
All right, our jury's left us, ladies and gentlemen. We'll be in recess 15 minutes.
You have an argument?
Before the jury does come in, counsel for the state has informed me that Mr. Steele now requests to put in the NPR video of the lyrics that Mr. Stephens just read. If he sanitizes it, as we did for the plea agreement, take out NPR, take out everything else, and just plays if it's a video of his client, I don't have a problem with that, but we haven't seen it, number one. And
Then why don't we do like we did customarily like last week? You show it to you and then I can make some determinations.
thank you. Mr. Steele, would you send that to us, please, some way or another?
Ladies and gentlemen, come on in. All right, thank you, Sergeant. Ladies and gentlemen, please be seated. All right, Mr. Sharp, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Stephens, we're almost done. Respectfully, Mr. Stephens, you do not wish to go back to jail, do you?
No.
And you know that there's nothing defense attorneys can file to send you back to jail.
Objection, Your
I
Honor.
sustain the objection.
Okay. You are aware that the state can move to have your probation revoked.
I sustain the objection.
Okay. To your knowledge, your testimony is being taken down by the court reporter, correct?
Yes.
Okay. And the state will have an opportunity to review your testimony at a later date, correct?
I sustain the objection.
Does the state have the
Objection, Your Honor.
I think
Speculation.
what?
speculation, yeah, that's speculation, so I'm staying the objection.
Please don't speculate, Mr. Stephens.
If you know,
Does the state have the power to move to revoke your probation?
Objection, asked and answered.
I sustain the
He-
objection. Been asked and answered.
Did. How does
Okay. If it's been asked and answered, then I have no further questions.
All right, thank you, sir.
how is something speculation if they were just arguing that he was signing and aware that this would be a term of the plea agreement? Because she read out those terms during direct and redirect. So how would all of that even be speculation? Because technically they also argued you knowingly agreed to all of these things. So it seems a bit contradictory that you would call that speculation, but okay. Yes, yes. In the words of Fatima, Amanda says, mouth almighty. Jesus. Yeah, right. And then how can it also be speculation? So there's no answer, and then asked and answered. And Shark caught that. He's like, all right, well.
So I'm staying the objection.
Please don't speculate, Mr. Stephens.
If you know,
Does the state have the power to move to revoke your probation?
Objection, asked and answered.
I sustain the
He-
objection. Been asked and answered.
Okay. If it's been asked and answered, then I have no further questions.
All right, thank you, sir. Anybody?
Also, like, probably not a good look if you have a defense attorney. I guess it doesn't really matter what side. If you have counsel making the argument that the other side will get angry at you and do something out of spite when they don't get their way, what type of look is it to be acting this way? It just lives up to the characterization being implied by the defense attorney.
Else have any recross? All right, Mr. Matthews.
Well, that was a good way to get worked up in the morning.
Mr. Stephens, good morning.
One.
Mr. Stephens, on December 29th, 2022, when you entered your plea, you went home in about 2 or 3 days after that, right?
Objection, Your Honor, asked and answered.
I don't think that's been asked and answered, Judge.
I'll rule the objection.
About 2 or 3 days or so processing, you got out, right?
Yes.
And since you've been out, you've had an opportunity to get back to work, right?
Yes.
Get your CDL license or apply for it, right?
Yeah.
You've been with your family, right?
Yeah.
And you were able to drive, right?
Yes.
You're able to eat what you want to eat, right?
Yes.
Go where you want to go, right?
Yeah.
Now-
Question, it was asked.
Basis.
Prosecutor didn't answer.
It's not, Judge.
I'm going to give you a very short window because we did cover much of this already, and you did as well.
Right.
So, all right. So, just
Okay.
I'm
She got to repeat her entire direct on redirect. So, what is this? What is this?
gonna allow you a few more questions.
Thank you. Thank you so much, Your Honor. So, Mr. Stephens, you were able to do all those things, right?
Yes.
Okay. Now, if you had not taken that plea and gotten out, you would be sitting over here, correct?
Objection, Your Honor.
I stand the objection to speculation.
Where do you believe you would be sitting?
If I ain't take the plea?
Yeah.
Objection.
I stand the objection.
And everything that we have gone through with respect to your plea, it is your hope that you don't get revoked, correct?
Yes.
Thank you, Judge.
You're welcome, sir. Any further examination? All right, Mr. Steele.
And Your Honor, prior to tendering of any
Yes.
exhibit, you asked
The
that
court
the court
knows.
allow the state to address and ask that Mr. Steele not tender the exhibit until it has been addressed.
All right, I'll tell you what. Ladies and gentlemen, the hour is about 12:45. How about you take some lunch? Fair enough to you? All right. So, ladies and gentlemen, it's about, if you could come back at, say 2 p.m. Okay. And we'll continue on with where we left off. All right. I remember my admonitions I've given you as well. They apply equally while you're at lunch. And ladies and gentlemen, we'll see you at 2 o'clock. Okay.
What is she staring at? Yeah, and LaDonna, I completely agree. LaDonna says, and with Love objecting like that, it's like she has something she doesn't want the jury to know, leaving the jury to wonder and question her. Yep, I'm big on like the squirrel, the shiny object type of, once I start thinking about something, now I'm thinking about it. And the way she yells her objections, it like spikes my blood pressure. It amps me up. It like gets some adrenaline going. So I'm going to be tuned in when she's doing this. And when it's rapid fire like that about simple questions like, you can eat food of your choosing. Well, now I'm wondering, just let them say it. Now you're calling attention to it. And not for nothing, but there's been so much, and this is, again, I've said it before, this is not the first or second or third. This is probably like the fourth or fifth time that I've watched through most parts of Tick's testimony. And we just had a weekend, we just came back, but we've watched like all of it. More than once, most of us. And all I'm thinking about is the plea deal. If I sat and marinated on it, I could start thinking about the little things that he testified to, like what happened when he traveled for the tour, why he didn't travel the one time, whether there was these little things. But it's so foggy, and the most prominent thing is this plea deal back and forth. And that's not helpful to the state at all. But Love made that, she kept emphasizing it. It's not really, the defense did a great job with it, but most of the conversation about the plea deal and demonstrating how it's used as leverage came from Love herself. Just stupid. Let's see. Let's get back to where she comes back and argues about dropping jewels. Look at Glanville's face already at Steele. Hopefully we get sound. Yeah, it's the court. It's not, because there aren't even captions or anything. Wish granted, you guys. They muted Love. Oh my God, did they mute all of it? Oh, they had to trim it. That's why. They probably had to trim the back. Ah! They're gonna get me.
Have this setting and Mr. Williams and
The complete version of
not his, the object to hear two things regarding the video. If it's the words that Mr. Steele wants the jury to hear, we would ask that the court require, and especially when the objection is based on, in part, on the fact that we didn't read all of the lyrics, we would ask, if that's his reason, that the court permit him to play for the jury, not a tiny disc concert where some of the words are left out and it's a different version than what's been released, but to play for the jury, the official audio that the state just played as it has been released.
So let me see if I understand your objection. Is your objection based on the rule of completeness and the official audio would be the complete version of the song?
In part, yes, certainly. And
All right, is there another basis for your objection?
okay, so the other part that we objected to, of course, was the NPR, that tagging, and there's no need to have this setting and Mr. Williams doing a Tiny Desk concert when.
I understand.
Yes.
Okay.
So I will just wait for the court to address
Steele?
that one. And I'll, after he addresses that, I'll address that.
Ms. Hilton, you'll need to provide the court a copy of what you played from Mr. from YouTube.
Yes, sir.
Okay, so what's the next state's exhibit?
40 uniform.
40 uniform for identification? All right.
Yes.
Just want to make sure it's captured for the record.
Thank you,
All
Judge.
right, hold on.
I'm just doing a quick visual scan here of the timeline scrubber. Like, Steele isn't even speaking. He's not making an argument here, but look how much more Love is bouncing around and arguing for this. Over playing a video with lyrics that the court already heard.
Okay, Mr. Steele?
Your Honor, in October of last year, so it's 2023, I served upon the state the Tiny Desk, NPR Tiny Desk version of this song. So I was wrong when I said, I gave it to him at a break, and I apologized to the court and the state by saying that they didn't ever get it before. It's the same exact situation you don't want me to talk about, but that's not accurate. Again, number two, they're the same words. There are no words omitted. Number three, there's no official release. In fact, the Tiny Desk,
The YouTube
is
the 40 uniform state played says it's the official song.
yeah, by whom? And the Tiny Desk is July 27th, 2021. And the version that the state just played, States 40, is October 15th, 2021. So,
How do I know this is the official version of it?
It's on his page, the defendant Williams' page.
Your Honor, this is my time. I have the man on cross-examination,
Okay.
and I'd like to play this. And
But
then if the
their
state
obje-
wants,
Okay, but their objection is to the completeness and I guess the accuracy of this particular video, which would be defendant Williams 38.
the only thing that is not complete is when Miss Love read certain logos and lyrics. I am playing the complete song. What Mr. Williams said on NPR is Tiny Desk, which is Mr. Williams number 38, is going to be identical to the lyrics in October 15th, 2021. So I, at some point, get to choose how to do the case, and it's more.
I don't think it's a question of just you choosing the case. You're right. You do get to present whatever case that you, from what position you're presenting it from. But I mean, that's the state's objection. So
And I've listened to a lot of the state's objections, and I disagree with the objection. I asked the court that I did not open that. I was going to play it anyway in my case in chief, but the state asked question after question and lyric after lyric, not entirely. And I want to play the whole version, and I should not be handcuffed by the state saying specious things like they're not the identical versions or it's not the official version. I am playing what Jeffrey Williams said out of his own mouth live before this jury. They can see it, and it's more audible. You can hear it better. So that's what I choose to play, and I'd like to play it, and I intend to play it unless, of course, I would obey you always.
all right,
But that's what I'd like to do.
all right, that's the first thing. The second thing is the NPR logo and everything, and such as that we that the state's objected to. Can it be removed?
I didn't actually see it, but I don't know. I can't answer that question, but we can see. But I'll identify it as NPR Tiny Desk, and I will play it. I'm not sitting here,
The state's
advertising.
made an objection as to the NPR issue.
I made an objection as to a lot of things.
I know, and I've removed a lot of the things that for the last video that was thought to be played. It had some objections and it needed to be sanitized.
I didn't want any of that
Rightly so.
except for.
But I do think that sanitized meaning that it has things that are objectionable. So, and I agreed with that. I agree with the state. You should remove those markings if you're going to play that.
I will orient the witness though, and then I have to ask Mr. Kokum. He gave me a thumbs up, so I assume that means yes, but I don't know. But I assume that means it can be done. I don't personally know.
All right. I need
That's
to
what
rule-
Mr.
I need to
Cook
rule
wanted.
out. Ms. Love, I'm going to overrule your objection as to, I'm going to let him play it.
Your Honor, understood and understanding the court's ruling regarding that. Just as a matter of course, I would ask that Mr. Steele not be allowed to tell the jury or orient the witness by saying that it's an NPR tiny desk video
I would agree with that, Mr. Steele.
and that,
Sure, over your objection. Oh, over your objection, yes, sir.
and
What the harm is to tell the jury that he performed it on
And-
time, yes, and that's where it's from. So I respectfully ask you not to limit me. You know, the state of Georgia
Your Honor,
has put in so much character evidence over my objection. Now they're saying we don't want NPR because it's somehow, I don't really know how. I don't really know what's wrong with NPR or what's positive with NPR. It's.
I don't think it's the, I don't think it's the, it's just the, it's kind of like the proponency of the video that you showed that was objected to, law and crime, okay? I mean, and the state's objected to that too.
Chat, can you explain the difference between seeing the letters NPR, even if you know what it stands for and that it's a broadcasting company or not, versus the words law and crime, whether or not you know that that's another media company or not? What is the difference, chat?
Issue. So, I mean, I should probably remove that as well. So I don't think that that's beyond the realm of acceptable things to consider, because remember, the issue is the song itself. It's not the carrier. So if you could just go ahead and remove that. Mr. Kokomo says you can do it. We'll get it done during the break.
and Your Honor, one more thing.
Just one thing
Hold on.
about the law and crime. The reason I was offended by that, and when I say offended me, not your ruling or anything, because it says law, which some people would think like that's a good thing to have laws, and crime, and that's a bad thing. And we're charged with crime. That's why I wanted that gone. It wasn't like, law and the justice system. I wouldn't have had a problem, or just legal trials. I wouldn't have had a problem with that. NPR is not prejudicial to anybody.
You made your point, sir, over your objection. Please remove it. Okay, so we're going to go ahead and do that over lunch.
And so,
What
Your
else?
Honor, the other issue with that video snippet, Tiny Desk generally plays snippets of songs because it's a 30-minute segment where they play many different songs. The version that Mr. Steele is asking the court to play, I'm assuming for the rule of completeness, is not the complete version. The version that is the complete version is the version that is on the defendant, Jeffrey Williams's YouTube site, where he says this is by, and Ms. Hilton will share it with the court as I'm speaking. It is the version that he released himself on his site. So we're asking that since it is for the purpose of playing the actual lyrics that are being spoken by Mr. Williams for the jury in their entirety, that Mr. Steele not be allowed to cut out portions when that is the sole reason he wants to play it, and that he be required to play not this different version than what he has actually released. So, and the court can see Young Stoner Life records exclusively distributed by the entity after that, and hashtag Young Thug, hashtag Dropping Jewels, hashtag Pump, and so forth and so on. This is from the defendant's own website. And when he is offering it up for the reasons he is at least represented to this honorable court, we would ask that he not be allowed to confuse the issue and not play what is actually the official audio that the defendant himself released to the rest of the world, as opposed to the, video.
All right.
Thank you.
It seems like maybe I need to get granularity on, this might not be something I play right now. It'd be played right now because both of you have thrown around the word official, and I don't know what official is. And unless you all can agree upon it, because the reason I say this, counsel, is that it affects the rule of completeness. So there's either got to be an official release, which has all the song, and not just a remake of the song or a riffing of the song or whatever. But if that's the purpose of playing that particular song, then we need to have the correct version, because there may be different versions out there, all of them claiming to be, an original release. And I mean, and I'm okay. And I understand that artists release whatever versions for whatever medium or circumstances that they choose to do so, and that's their purview. But for this particular evidentiary issue, it would have to be something that both sides can agree upon, or somebody's gonna have to come in here and tell me this is what happens when that the official song is this.
Your Honor.
This is the Recording Academy, is whatever, I don't know. But
Your Honor, you are being, and I'm not saying it's intentional, You are being misled across the aisle from where I sit. The words are identical. You keep being told something is not accurate. So I will be playing like you ordered, unless you changed your order. I will be playing.
I haven't ordered, I haven't ruled yet.
You
I mean,
overruled the state's objection and you said that I could play what I want to play. And then Ms. Love just
but they're telling me that that's not the original version.
Of what?
The tiny desk, the tiny desk.
ask the question. What is omitted? The answer will be nothing.
Is anything omitted, Ms. Love? Is there anything omitted from the tiny desk version versus the YouTube version?
Your Honor, if the court looks at the time alone, the court can see that, but the point that we're making is that we ask that the court listen to both of them and then.
And I can't really, and I'll be honest with you, I can't really tell other than,
Then the court allow us a little lunch break to compare the two. Since
Sure.
there is an official version.
absolutely.
And so we will
Waste
do
of
that. We'll
time.
bring that back before the lunch break ends.
Okay.
And if, when the court tells me that the time is appropriate, I would like to address the second exhibit that Mr. Steele.
What's the second exhibit now, Mr. Steele? Is there something else you were gonna?
He has said, Mr. Steele has indicated that he seeks to introduce his client's words, and that is absolutely.
Client's words in terms of what?
An interview that Jeffrey Williams did about Jeffrey Williams. And so under 24-801D1C, the defendant Jeffrey Williams can take the stand and talk about what was in his head, but he cannot introduce it himself.
24 dash what?
8-801D1. Just 1 second, Your Honor.
Are you talking about prior consistent statement?
No, Your Honor, 24-801D2A. 24-801D2A, which says an admission, it's speaking to admissions by party opponent. A party's own admission offered by an opponent is not hearsay and is always admissible. This interview was not offered by the state. It is being offered by the person who spoke it. And here, however, according to Morales, Morales versus the state, 337 Georgia App 614 at 618. It is a 2016 case. A self-serving declaration, such as a statement of one's innocence and a statement of what words may mean, remain inadmissible hearsay unless the declarant testifies and is subject to cross-examination. And in this case, with what Mr. Steele is offering, the declarant is the defendant, and the defendant has to be subject to cross-examination by the state in order for the defendant to be able to properly admit the defendant's own interview in any venue. The state did not introduce that, and the defendant cannot circumvent 24-801D2A by making assertions that somehow, well, I'm not sure how he is attempting to get it in. He cannot get in his own words. He would have to testify. A declarant cannot attempt to introduce any such statement. It is well established in both state and federal law. And defendant counsel Steele cannot cross-examine the defendant about his statements made in the interview, whether the witness heard those statements, whether the witness saw the interview. Under no circumstances can Mr. Steele properly admit or have admitted that interview that the state has not sought to introduce, or examine the witness Trontavious Stephens or any other witness. He cannot examine or cross-examine the witness about the defendant's own statements or otherwise, unless the defendant is subject to cross-examination on the same. And I will point to United States versus Green, CR 415-204-3. It's a 2016 U.S. District Court case, and it's at Lexus 66739 at 3 out of the Southern District of Georgia from May 20th, 2016. Again, the state may properly introduce it, but as stated in Carlson on Evidence, the most recent 8th edition, the state or the right of a party to introduce the opposing party's statements is being affirmed by 24-801D2A. And according to, as reading in Carlson, since the definition of an admission includes admissions by conduct, the party's flight is implicated, And this rule is intending to adhere to federal formulations, and it allows for a standardized approach with respect to other specific issues such as flight. But as it relates to the defendant's statements, the only way that they are not hearsay is if the state seeks to introduce them. Otherwise, they are inadmissible and should be excluded. And as they go on to talk about in Carlson's regarding the policy and rationale, out of court statements made by a party opponent, if we were offering it, are an exception to the general hearsay rule. And this exception reflects that the adversarial process allows the party declarant to rebut his or her own statements by testifying at trial. Relevant admissions of a party are generally considered substantive evidence, and those statements are not admissible because of their inherent trustworthiness, but because a party cannot object to his failure to have a chance to cross-examine himself. If the state is forced to endure the defendant introducing his interviews left and right without being given the opportunity to cross-examine the defendant, then the state is unfairly burdened and is not allowed the opportunities that the law requires as it relates to a fair trial and getting the actual truth in front of the jury. And the defendant can just put in whatever words he wants that he speaks without ever having to endure cross-examination. Thank you, Judge.
All right. Mr. Steele?
Your Honor, 24-8-801 D2A, I hope the court finds does not apply. This is not a self-serving statement. This is a statement from 8 years ago. And it goes exactly to the topic that the prosecution asked a number of questions. I don't know how many, maybe 10, but I don't know how many, about Mr. Williams. Where in his songs does he say, God, truly humble under God? Mr. Stephens understood that to be humble. Mr. Stephens understood that to be God. Mr. Williams gives an interview. He explains, I want to be Jeffrey. Young Thug is a brand, but it sells millions, it makes millions of dollars. I want to be humble. I want to be harmless. Everybody now, because of my brand, comes at me and I have to go hard at them because that's what I portray. But I don't want it to be like that, and I don't want my children to be like that. That is all encapsulated. What Ms. Love did is what courts have told me, what you told me actually during this trial. I may have opened the door. I may open the door. I could be opening the door. Ms. Love opened the door. She now leaves the jury with the impression that this was made up, that this is not about being humble, that Mr. Williams is not about anything except a gangster. And he gives an interview well before this. The state cannot sit here and say the jurors get the truth and then hide the jurors in secrecy. She should not have invited those questions at all. But she did, she being the Honorable Ms. Love, and I get to cross them because otherwise.
So what's your basis for saying it's admissible? And how long? That's my first question. Second question is, how long is the interview?
3 minutes. It's longer, but I'm just going to show the relevant part. But I'm going to put in the whole thing. But I'm just going to show the relevant part at 3 minutes. It starts at 9 minutes and 10 seconds, and it goes for about 3 minutes.
Yeah.
It might even be less.
Here's the
It
issue.
might be less than 3 minutes actually.
So what's your evidentiary basis for putting it in, Mr. Steele?
Because I am going to show that the impeachment of the state on redirect was erroneous, and that this witness has knowledge that it's erroneous. He keeps saying
It's got to be that witness's statement. It's got to be that witness's statement.
They're asking about Mr. Williams' statement. That's
No,
all.
but what you're trying to introduce is what's a better part of a prior consistent statement.
No, I'm not trying to do that. Ms. Love put in on cross-examination, excuse me, on redirect. She said, when did Mr. Williams ever say truly humble under God in any song? Then it got into a conversation about God. That's how you got into that song that we've been talking about.
Dropping jewels.
Exactly. That's the whole way that God got introduced into this case. Then Ms. Love, that was before the break. Ms. Love then today continued that. And she said, name any song, anything where Mr. Williams talks about truly humble under God, humble God. And she put the gentleman on the spot and he said, I know what he's saying. And Ms. Love then started to read the words out of context and not complete of the song Dropping Jewels. So I want to show that that man is not lying about this, that Mr. Williams has said to everybody, and I've served it on the state, has said, this is a big deal to me. And that's why I would like to bring it in. And I don't believe that the state can hide behind 801 D2A when they open the door. They shouldn't have asked these questions. The evidence is there, and it's not a statement that goes to innocence. It has nothing to do with innocence. It goes to show what the state is going to do if you don't allow something like this is if we were at a closing argument, they would say that whole thing is made up. There's nothing about being humble. There's nothing about God. You heard dropping jewels, and sure, one part is interpreted as God, but he never says God. That's exactly the opposite of the truth. And she was asking Mr. Stephens for the words of Mr. Williams. Those words are clear. So I asked the court to admit them.
Inching up with the
Your
book.
Honor, briefly, Mr. Steele opened the door and during opening statements, the state intentionally did not want to prejudice his client in any way when he began offering self-serving statements about thug, meaning truly humble under God. We approached, the court heard our objection. They're self-serving. This is a self-serving declaration by the defendant Williams that Mr. Steele not only opened the door on, or even spoke about rather, he cannot open the door to have his own client's words admitted over 24-801 D2A. Not only did he speak about that in opening statements, knowing, because I said, if his client is going to testify that that's what it means, then fine. Mr. Steele at the court's bench said they are going to be able to get it in. And so what Mr. Steele did was ask Trontavious Stephens on cross-examination about various aspects of the defendant being, I guess, truly humble under God. What Mr. Stephens did was talk about what he knows the defendant has rapped about. And when I asked him, because he's a founder of YSL, okay, well, how many songs has he written about God? And then Mr. Stephens starts to talk about this. The reason we don't object to the audio of dropping jewels being played is because the only thing that Mr. Stephens can talk about, because he's the one opining that this is about God. We don't believe it's about God at all. But the only thing he can talk about is what he heard. He responded that dropping jewels is about God. So I said, okay, tell me what part. Is this about God? Is this about God? To suggest somehow that because defendant Williams in opening statement makes this absurd assertion that this means whatever he claims it now means.
But here's the thing. He doesn't have to present anything.
He doesn't.
And remember, opening
Right.
remarks and closing statements of counsel are not evidence.
Right. I don't disagree with the court on that at all, but it still does not, even aside from him saying whatever he wants to say in opening statements, that interview by his client is not just a self-serving, it's not just a declaration by his client that the state would not get the opportunity to cross-examine his client on. It's a self-serving declaration, regardless of when it was stated. And we in no way open any doors to him putting that in. The only way we would do that is to play it ourselves. And if the court would permit me one moment.
What do you need another moment for?
Mr. Steele, this is an interview that you're trying to introduce, and what's it going to be marked as?
Mr. Williams, number 39 on today's date, Your Honor.
Why is she nodding? Oh,
And also, Your Honor, Ms. Hilton has just further brought other facts that we would like to bring to the court.
Can I rule on something first? Can I get just a little bit of
I'm so sorry.
time just to kind
No,
of
you're not.
consider what you told me so far?
Yes. Thank you.
She's just doing circles. She's just like doop, 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 doop. Getting her steps
Okay,
in.
so during the break, you all are going to work on whether or not or come to some agreement on defendant Williams 38 or states 40. As it pertains to defendant Williams 39, Mr. Steele, I'm at this point in time believe it would be, I'd probably sustain the state's objection in regards to it being coming under 24-8-802, 801 D2 alpha. So at this point in time, I'd probably not admit that statement at this point. However, I'm not going to say it's not admissible at some point. Should you choose, or should the door be opened by somebody else?
So remember when Whitaker ends up taking over and she's just like, oh, we'll go with whatever the prior court's ruling was. This is one of, and I think we've seen like 3 or 4 of them already, issues that are argued for 10 minutes or more, which I don't know how to really weight that, because if I'm going to argue something for 10 minutes, it's a significant issue. I don't know if that applies to something that Love is arguing. It could be insignificant and she'll argue it for an hour. But for just my little thought exercise here, Whitaker comes in and there's multiple. We're only on day 21. We're only watching clips of Love. We've already seen multiple arguments that in theory should be significant because they've wasted 10 minutes or more on them. And he's like, oh, I'll defer to making a decision until later. And then Whitaker comes in like, oh, we'll just go with the decisions the prior court made. Like, there's issues in general with mid-trial substitution of judges, but a trial of this magnitude with the ingredients, with this lady and this judge leaving so much up in the air, just like the worst trial to mid-trial substitute on. So,
I'm not saying that the statement might not have any relevance or probative value, but at this point, through this witness, it would violate 24-8-801 D2A. All right. So unless there's anything else, folks, I'll see you in about 30 minutes, okay?
Thank you, Judge.
alrighty. So I think that's it for Love on. Oh wait, no, wait, she's back. I lied. Oh my gosh. And it's so funny to me because I know what's about to come up. So we're on day 21. I went and pulled clips of something that Atkins argues about on day 22 and then 23. And I'm going to play it for you guys, not because we're just darting over to an Atkins palooza, but because I swear that Love put him up to making this argument because of the failure here. Well, not really a failure here, but she knows, I think she's agitating the judge. Just right back to her with her book.
Okay, starting everybody here.
Looks like everybody's present to come for, Judge.
Okay, when we recessed counsels, we were talking about defendant Williams 38 and states 40. So we proposed or got into a resolution of that.
So, Your Honor, Mr. Brown is going to go and look at what they have put together, Your Honor, on conferring further with counsel for the state, Mr. Carlson in particular, with respect to sentence 28, was it?
38.
30, thank you, Judge. The video itself, Your Honor, is inadmissible hearsay under 24-8-801A through C and 24-8-802 and Rule 613. Per 24-8-801, the exhibit does not have to be self-serving as it did under the old Georgia law, only self-quoting. That is what makes it hearsay under 24-8-801A through C. And it is therefore inadmissible under 24-8-802. To properly have the video admitted, the defendant bears the burden of providing to the court an exception or an exemption to the hearsay rule, and the defendant has not met that burden because there is no exemption or exception that applies. The video is not a prior consistent statement under Rule 613 because the defendant has not testified. Therefore, the statement is banned as bolstering before impeachment under Rule 613. Your Honor, with respect to the video itself, the state has left the jury with no misrepresentation or false portrayal about what the lyrics of the song are. And so the rule of completeness, the doctrine of curative admissibility, does not apply. The meaning of the lyrics is a jury issue that the defendant cannot prove by circumventing the hearsay rule with a self-quoting video. Even for the sake of argument, if the state has in some way misrepresented to the jury what the lyrics are, the state did not introduce a video. So a video is not admissible under either of these doctrines. The only thing that would be even conceivably admissible would be the specific additional lyrics that provide a different context than the ones the state introduced from that particular song with this witness. Lastly, Your Honor, introducing the video is barred by Rule 403 in that it would confuse the issues for the jury. Because while we here now are focused on lyrics, suddenly the defendant would be introducing a video. That comes in and that is confusing the issues as to what they really are. And so our position is that it is barred by Rule 403 under confusion of the issues, Your Honor. So when the court asked the state to look for lyrics that were different between the two versions, it is actually the defendant, if that is his grounds for having to admit the inadmissible hearsay video. The defendant bears the burden of presenting to the court what misrepresentation the state has made, and then he is limited to playing only the portion of the song that would then give proper context to whatever misrepresentation regarding the lyrics that currently exists as the state presented in that particular song. I would also point out now that it was the defendant who asked and brought up on cross-examination. We're not even talking about open, but on cross-examination, the defendant specifically asked Mr. Stephens, does thug stand for truly humble under God? Your Honor, and that is the only reason the state went back and said, if this is what his name stands for, and he sings about everything else, how many songs has he written that talk about being truly humble under God? So in the 8th edition of Carson on Evidence, Your Honor, page 269, page 80, page 51, and page 432, page 336, and page 438, all pertain to the inadmissibility of this type of evidence and the video in particular. And the defendant simply is not permitted to make a circumvention of the rule excluding hearsay. He has not provided an exemption or exception. And I think that I see the court has a version of Carlson, and if I've given the court information from an edition of the court.
I'm not as rich as you all are, so I don't have the most recent version, but I am familiar with Carlson on Evidence. So I'm good. I'm good on that. But
Thank you.
anything else? Okay. All right. Mr. Steele, anything, sir? In regards to, I guess, it'd be Williams 38 for identification.
I made my record. There are no differences in lyrics. Prosecution introduced lyrics out of context on redirect under the rule of completeness and under truthfulness to this jury. I would like to do what you already ruled and play the song. And I don't even understand how we're at 24-6-613 prior consistent statement. That's not even close. I mean, we're talking about, you're saying, okay, it's snowing, and we're talking about, well, let's go, so since it's snowing, let's get our pails and shovels and dig up the sand. I mean, this is crazy, their argument. So I didn't bring this up.
Okay.
No intention of playing it.
Mr. Steele, I do understand that. I really do. But
I just want to play the song.
But you can't at this point in time.
Yes, I can. It was brought up with this.
Okay, but you know what? It's still inadmissible at this point. It's not admissible at this point. I would agree with the state under 801, 24-8-801 A through C, 802 and 613.
At some point, the confrontation clause has to speak in this courtroom. The state of Georgia asked and leveled words made by Mr. Williams. I want to put those words in proper.
Okay, but you won't be able to do it through him. It's objectionable.
Right person.
It's objectionable at this point in time. I'm not saying that it's not. I'm not, like I told you before. It's not that it may not be objectionable at this point, but if evidence comes in for different reasons, Mr. Steele, at this point in time, it's just not coming in. I'm not saying that it won't come in at some point in time.
This court is handcuffing the Constitution. Then I move to strike everything said by Mr. Stephens in its entirety because I can't confront it. You have the awesome power to control these proceedings, but the state of Georgia wide open that door. I didn't mention anything.
Okay, but that does not make the evidence any less inadmissible. It doesn't.
They took words out of context. And I want to put the words in its entirety the way they are. You should be able to let me see the road to do that, Your Honor.
I just can't let you do it right now, Mr. Steele. It's because the state's objected to it, and I agree with them under 801 A through C.
Well, they're wrong. Mr. Carlson has no clue what he's talking about. He's wrong. He wasn't here. And just to throw around a name because he wrote a book, this is not applicable, Your Honor. The state of Georgia said, this is what Mr. Williams said. I'm saying, actually, what he said was this, and I'm putting in the completion of the story. You know what this song is about? It's about coming from nothing. It's about telling your kids, not that you're riding around with a body. It's about telling your kids, if you live under the circumstances that a gentleman like Mr. Williams did, you may have to kill somebody because they're going to kill you. It's self-defense. The state of Georgia wrapped all that up in little lyrics and misconstrued what they are. I have every right. I need to put this in. And it's not good enough to say later, Judge, this trial, I have no clue. I've never been in a case like this. This trial may go on till Super Bowl next year. I don't want to do it in 7 months. It is right now, and I should have the authority to do it, Your Honor. You know, I'm doing everything that I know to be upfront. I give everything I don't have to give. I give everybody a heads up, and I get spun around. I get to play this song, the song I want to play, and I ask you not to keep doing this and listening. Once you rule, it's coming in. Which one? The state was saying before lunch, I'm somehow changing the lyrics. The lyrics don't change. I tell you that. Now it's all of a sudden another reason. Your Honor, you have ruled. I use your ruling. I embrace them, and I am correct. There has to be a point that we have traction here too. It is a two-way street.
But remember, Mr. Steele, I can always, one of the things about being a trial judge is you can reverse your rulings. And also, here's the other thing as well. You all as a group, kind of release or give me snapshots at any given point in time. And I make a ruling on it. Then more comes out. And I sometimes at that point when I get a full picture of everything, because remember, this is part of what challenge I told you about earlier. When it unfolds this way, I don't get to make the best ruling I can at the first time. So unfortunately, I'm kind of hamstringed in terms of that, but I do have a mechanism of kind of reconsidering.
No, if you want to look at your own case law, you can go do that and you can make your ruling. What the heck is this?
Comes out. And I sometimes at that point when I get a full picture of everything, because remember, this is part of what challenge I told you about earlier. When it unfolds this way, I don't get to make the best ruling I can at the.
What unfolded? And what unfolded this way? They've been arguing for like 2 hours, it feels like, across 2 different breaks about, and Love bled 2 issues together. But confronting definitions with lyrics and showing the complete picture with different media. That's all this is. What has unfolded this way?
First time. So unfortunately, I'm kind of hamstringed in terms of that, but I do have a mechanism of kind of reconsidering. I want to get it right just like anybody else does.
Your Honor, I learned about it today. Dropping jewels was mentioned on redirect. I brought it to the court's attention and the DA's attention before that. Your Honor.
And that's why I'm not fussing at anybody about it. I'm not, Mr. Steele.
I get to put it into perspective.
Not now.
Oh, Judge, please take a
minute
break and reconsider because this is important.
Everything's important, Mr. Steele. Everything.
But good. Then I need to put it in. You told me over and over again, there's a battle of the titans. You can cross-examine. Well, I'm here.
Okay.
And remember, 2 days, or actually, I think it was the beginning of day 21. It might have been day 20. He was insisting to Bruce Harvey, and I think a little bit to Max Shart, that Georgia doesn't have these limitations like the federal rules where a prosecutor would be constrained on redirect to the subject matter brought forth before redirect. And now he's forgetting how long that argument was and how much he insisted on that.
You're doing your job.
I want to do this. Every time the state wants to put in something like that last video of Mr. Stephens, I strenuously object. You overrule it and you say you can deal with it on cross. Well, the state's the one who opened the door. I get to go into this. They just mentioned a song and lyrics from the song. They knew what they were doing today. They brought lyrics with them. It was mentioned before Mr. Stephens ever came. They didn't ask you, hey, I'm going to mention lyrics. They just do it. I get to respond. Your Honor, this is critical to me. They are trying to paint Mr. Williams as a person he is not. This is a good man. And I get to show the truth about that song. I didn't introduce the song. I gave it in discovery because I will introduce it later. But now it's wrong. And if you don't let me do it, jurors form opinions. I know you're instructed, but they form opinions. That's why we confront witnesses immediately. It is wrong to exclude it. At this time, it was wrong to exclude respectfully lifestyle. They put in the rich gang shirts. I want to show what lifestyle is. You told me do it with another witness. Your Honor, this is the witness. I need to do this. This is the only way I can get a trial.
Look, you have the right to present whatever it is that you feel you must on Mr. Williams' behalf, as each advocate does here. But there is a certain order, as you all know, that the evidence code requires certain pieces of evidence to be admitted. So subject or unless they're by agreement, if there's an objection, then I have to rule on it.
Judge, this was the state's doing. They used part of the song. How is it just? You're a great man. How is it just that the state got to put in their own inflection of voice on lyrics and say, is this what the song says? And Mr. Stephens saying, yes, it does. Next lyric, is this what the song says? Yes, it is.
And by their own inflection of voice, they mean Love's inflection of voice.
The next lyric, is this what the song says with the expression? I'm not going to say it, but the emphasis on the word F. You blank K. And then I sit here mute. That's just, they did this. And I get to put it in perspective.
Okay, but
I need to do it now. And it is right now because it's a rule of completeness. The witness knows the song. He knew it from his memory. Miss Love was saying, you know the song, here's the song, here are the lyrics. I want to put in the actual song. The way I want to put it in the video, and then we're done. But Judge, to exclude it, it makes it look like I'm conceding it, and I'm not. And I would not. And to hide behind a hearsay statement when you open the door on that specific statement. I was thinking about this over lunch. What if the police officer, for example, said, yes, Mr. Williams gave a statement to me and he admitted being there at the time of the incident. And then the state sits down. And then I want to get up and I want to say, I want the whole statement in. Mr. Williams admitted that he was there at the time of the statement to help the victim. How is that not the same here? The state is saying, Mr. Williams said this, 1, 2, 3, I think it was 4 different lyrics. Why can't I say, but Mr. Williams put it in context, and that is what the song's about. The state cannot now tell the court, let's keep it away. It is wrong. Your Honor, I'm not begging. I'm respectfully requesting this honorable court to do what you already ruled, and you do have all the information. It was the state's doing. It's not like I'm just standing up and saying, I want to play every one of Mr. Williams' songs. I picked the song because the state picked the song. I picked the words because the state picked only a portion of the words. And I picked the Tiny Desk because it's clarity. It's easy to hear the words and the lyrics. That is all admissible. If the state wants to play the other rendition, I don't care, play it all day long. But it's not for the state
Sorry.
to tell me what I can and cannot do on admissible evidence. And I ask the court to please permit me to try this case so the man has an opportunity to get the truth out. It has been maligned.
All right, sir, thank you.
So that's it.
I'm going to be in recess.
Oh my God, they still have this poor guy on the stand. And he's hot. He's taking off the jacket. I used to love when he took the jacket off. You knew it got real. Hey, positive Q.
Merci, comprendre.
Okay, of course, I have opportunity to consider one more arguments of counsel. In terms of Appendix 38, States 40, I'm not going to do it. I'm sorry, Mr. Harvey. I said, as it pertains to Defendant Williams 38 and States 40, I'm going to not admit them at this time. All right, can we call for our jurors at this point? Let's call for Mr. Stephens, please. All right, ladies and gentlemen, please be seated.
I'll do President Counsel.
All right, thank you, Sergeant Ingram. All right, any further examination of Mr. Stephens? Mr. Steele? Go ahead, sir.
Good afternoon, sir. Mr. Stephens, do you remember today the prosecutor was asking you questions about a song called Dropping Jewels?
Yes.
And do you remember her with her inflection of voice? What that means is her tone of voice, the way she was speaking, giving you certain lyrics allegedly from that song. Do you remember that? It's not. It was one question.
Just rephrase it, Mr. Steele.
Do you remember? Okay. No problem. Do you remember the prosecutor asking you questions about certain lyrics from that song?
Yes.
And do you remember they were a series of questions? I don't know how many, but 3, 4, 5, 6, something like that. Do you remember that?
Yes.
And do you remember her voice stressing certain words?
Yes.
And do you remember, like, and I'm not going to say it, but, you know, for example, when the Honorable District Attorney Love stated the word begins with an F and blank CK, remember how she raised her voice for that? Remember that?
Yes.
Okay. Now, you clearly know the song Dropping Jewels, right?
Yes.
And you've heard that song multiple times, right?
Yes.
And it was written by Jeffrey and a man named Chandler Durham. Remember, let me ask you a question. Do you remember the prosecutor asked you, do you know Chandler Durham?
Yes.
Okay. Do you know a gentleman named Turbo?
Yes.
Okay. And Mr. Williams or Jeffrey wrote the song with him. Do you know that? If you don't know, just say, I don't know.
I didn't know that.
Okay. Now, Dropping Jewels, the name of the song, tell ladies and gentlemen, jury, what does the expression dropping jewels mean?
Objection, speculation,
That's-
as it relates to the defendant's song.
I'll sustain the objection. If you can lay a foundation, sir.
Have you heard the expression dropping jewels before?
Yes.
Do you know what it means?
Yes.
Can you please tell the ladies and gentlemen, jury, what the phrase dropping jewels mean? They may not
Objection,
know.
if it does not apply to the defendant's song, it has no relevance.
It was-
If it does apply to the defendant's song.
Okay, okay, all right, let me rule on the objection. I'm gonna overrule the objection. If you can answer, do you know what dropping jewels means?
Yeah.
All right.
Like teaching somebody like wisdom or knowledge.
Okay. Just because I couldn't hear you, can you just repeat that to the jurors if you don't mind?
Teaching someone like wisdom or knowledge.
And in those lyrics that you were asked about, we're going to go through a few of them, or all of them if we can. You were asked about a lyric, something to the effect of, and I'm not saying the prosecutor said it correctly, but something effective. I told my son if he wanted to live, he might catch a body. Do you remember that as a lyric in the song that you were asked about?
Basis.
As to mischaracterization of what I said, and mischaracterization as to the lyric itself.
All right, I'm gonna overrule the objection.
Do you remember that?
Yes.
Is that a lyric in the song?
Yes.
Okay. And from where Jeffrey came from, was there times that people had to defend themselves?
Objection, Your Honor, speculation.
I sustain the objection.
Where you came from, were there times that people had to defend themselves?
Objection, speculation.
And
relevance. That's the word.
Well, I sustain this irrelevance.
If somebody wants to live and they catch a body, well, what does catch a body potentially mean? I know it can have a different version, but what does potentially catch a body mean? Tell the jurors.
To like kill someone.
Okay. So if somebody wants to live and they have to kill somebody, you ever hear self-defense?
Objection, Your Honor.
I sustain the question.
Do you know what that lyric means to
Objection,
you?
Your Honor, speculation.
I'm asking about
I think he's
Mr. Steve.
I think he's answered that question. Can we move on to something else?
With regards to,
You answer that?
you were asked about, I just hopped up out that ghost. I've been driving a dead body. Is that a lyric in the song?
Yes.
Okay. Tell ladies and gentlemen, jury, what a ghost is.
Objection, speculation.
I sustain-
you know.
I sustain the question. You can rephrase her.
If you know, is a ghost a Rolls Royce
Objection,
vehicle?
Your Honor, speculation as to what those means in this song.
I asked,
Well, let's just,
I didn't
just ask him the question.
does Rolls Royce make, do you know what a Rolls Royce is?
Yes.
Is it a vehicle?
Yes.
Does Rolls Royce make a vehicle known as a ghost?
Yes.
And if you're driving a ghost, are you driving a dead body?
Objection, Your Honor,
Basis.
speculation.
I sustain the question as to that.
Is a ghost somebody who already died?
Objection, Your Honor, relevance.
I sustain the question.
Is that the lyric in the song that you were asked about? Is that the
Objection, Your
line?
Honor, clarification.
I'll rule that objection.
Is that the line you were asked about?
Yes.
Okay. Does it have anything to do with killing anybody?
Objection, Your Honor, speculation.
I sustain the question.
Who is it? Okay. You were asked about the line, or is this a line first? I was locked inside the trap, didn't think about it, but I got out of it.
Yes.
Okay. And is that getting out of a neighborhood, a
Objection, Your
bad
Honor.
neighborhood?
Speculation, and I object to any questions regarding what Jeffrey Williams means in these lyrics that the witness is reading.
I sustain the answer to the question posed right now.
From what the prosecutor asked you is, I was locked inside the trap, didn't think about it, but I got out of it. Is that getting out of the neighborhood?
Objection, Your Honor.
That's an answer. I sustain the question.
Gonna stay
Do
standing.
you remember the lyric? I just came up watching my pops gamble my food stamps. Is that a lyric in that song?
Yes.
is a lyric in the song, "Is it bad? You better get rid of it or lose on it. I know you heard that old saying, folks round about bad fruit." Is that the song, the lyric? No, tell the lyric.
No, you didn't say it right.
Go ahead.
You want me to say it?
Yeah. Tell the jurors.
Start it off. Let me see what part you was on.
Okay. Is it bad? You better get rid of it or lose on it. I know you heard that old saying, folks round about bad fruit. Oh, that's fine. Mr. Stevens,
If it's bad, you better get rid of or lose on it.
okay.
I know you heard that old saying about bad fruit, food, one of them, fruit or food.
One bad apple spoils the bunch.
Objection, Your Honor, that Mr.
I'm
Steele
asking-
is asking what the meaning of the lyric is, because there is no testimony.
So what's your objection, madam?
So objection as a speculation.
I sustain it.
I'm not asking, okay.
Just sustain it.
To you, that old saying, what is that old saying? If you know,
Objection.
What are we talking
that
about?
the lyric refers to.
Objection, speculation.
Mr. Steele, I'm standing, bring him back to what is it you're asking him about in terms of the, because I don't think he's been able to identify anything at this point, so.
Dropping jewels, Mr. Stevens, is about teaching.
Objection,
Right.
Your Honor.
He's already-
Speculation.
He already said that's what it means,
Your Honor, as to the song.
I'm gonna overrule the objection.
correct?
Yes.
I couldn't hear you.
Yes.
And Mr. Williams talks about his son and daughter in that song, right?
Yes.
And he wants them to know what a struggle it is, right?
Objection, speculation.
I sustain the objection.
That's what the song is about to you,
I sustain the
isn't it?
objection.
Speculation.
To you, is that what the song is about?
Objection, Your Honor.
The state asked all about the
No,
song.
hold on, I'm overruling the objection. Let me get the question out first.
To you, the song Dropping Jewels, it is teaching children to go a better way, right? Teaching about the real life, right? Warning them.
To me, he's talking to his kids and he's talking to other people too, teaching, saying the things, life coping skills. I don't know.
Okay. All right. Now, I want to talk with you about some of the chats that the prosecutor was asking you about, okay?
Yes.
And I just want to start here. Your Honor, with the court's permission, can the Honorable Mr. Kokomo put up Mr. Williams, number 2? It's already in evidence.
Yes, sir.
Your Honor, will the court permit me also to just grab that from the court reporter stand just to follow?
Yes, ma'am.
I'll be just Mr. Steele, please.
I have.
Just give me the page numbers from that exhibit 2 consists of, at the very top of the page.
1603,
1603 to
2 pages.
1604? Okay. Is it 165?
Mr. Stevens, if you don't mind, and if you can't see that for whatever reason on your screen, we have it in evidence already. You can look at it, okay? Just let us know. I'd like you to just show,
Your Honor, I'd object as to the state having asked no questions about 1603. We asked about defendant Williams 4, not 2.
Sorry, is this defendant, which exhibit is this? I'm sorry.
number 2, Your Honor. Mr. Williams, number 2,
In evidence already?
of course.
Let's see where it's going. I'm gonna overrule it for the time being.
Okay, you see at the very top right-hand corner on Mr. Williams, number 2, it says 1603. You see that?
Yes.
Okay, and then the next page, just to give you an idea, and it's the second page of Mr. Williams, number 2. For ladies and gentlemen, jury in the ensemble court, you see in the right-hand upper corner, it's in like blue and white, 1604. Do you see that?
Yes.
Where it says Instagram business record?
Yes.
Okay. If you can just remember, if you can, otherwise I'm going to show it to you, no problem. 1603, if you could try to remember that. Now, in 1603, on the page before, Mr. Kokomo, at the bottom, towards the bottom of that page, you see at, let's see. See where it says bully with two eyes, one at 1:59:09 UTC time on your, like kind of like the top center of your screen. See where it says that Instagram user sent an attachment?
Yes.
And the text says yo at little Uzi Vert. You see that?
Yes.
And that's a gentleman you already explained to, ladies and gentlemen, jury on that date, which is February 4th, 2021, revealed that he had a surgically implanted.
Your Honor, asked and answered on cross, and I didn't even ask about it on regret.
Oh, objection.
And that's the gentleman who you already talked about on that date, revealed that he had a surgically implanted pink diamond in his forehead. Is that fair to say?
Yes.
Okay. And that gentleman's a performer, right?
Yes.
And then underneath it, it says this real. Is that fair to say?
Yes.
And then the next one is that N Uzi crazy. This is all about his diamond in the forehead, correct?
Yes.
Okay. And then that boy take a punch to the head. It's over. And then on the next page, which is 1604.
Your Honor, I object to the, I don't know if that was a question, but it's testifying, I object to testifying.
I'll sustain this to the form of the question. You can rephrase, sir.
I was just asking Mr. Kokomo to go page 1604. And you see that at the top, they trip it now.
Yeah.
And then he cap. And then Jeffrey, YSL Rule the World Kid 24M on an instead. You see that?
Yes.
And then you said came from nothing for something, right?
Yes.
Okay. And then you already said it, but in Mr. Williams number 3, which was played to the jury, that's what we're talking about, which I'm displaying, Your Honor. Already in evidence. It's a video that the jurors saw. That's the photograph of Mr. Little Uzi Vert having the pink diamond in his face, right?
Yes.
All right. Now, I want to show you what already been identified by you.
Your Honor, as to the line of questioning regarding that, you have not objected to asking that.
I'll stand that.
Okay, I'm going to
I
show
believe
you
in
now.
paying attention.
Mr. Williams, number 17, it's already been displayed to the jurors. Your Honor, I ask to display it again. It's over at number 127.
Yes, sir.
Now, I'm going to hold it up. I've been told that jurors can't see it, so I'm not going behind you, okay? Can you see it though, Mr. Stevens?
Yeah.
All right. And you see where it charges in count 1 over at 127, February 4th, 2021, that these gentlemen, Mr. Lee, yourself, Mr. Williams, associates of YSL, did engage in conversation with Mr. Williams states.
Your Honor, I object,
YSL.
he has already asked the same exact question on cross-examination.
Let him finish and then I'll make a ruling.
Yes,
YSL ruled the world, kid 24M, 24M on an N's head. See all that?
Yes.
And then the next line, it doesn't have any type of
Your Honor,
comma.
as to the commentary.
I'm on cross.
Is there a question though, Mr. Steele?
Yes.
Okay, all right. What's the question?
I'm getting there right now. And you see how it just continues in the indictment? You all just start bringing me the money?
Yes.
All right. And then, man, you aims, stop playing with me. See all that?
Yes.
All right. Now you remember that 1603 and 1604 that we discussed already?
Yes.
All right. Now I want to show you what's already been marked with Mr. Kokomo's permission, Your Honor, and admitted into evidence as Mr. Williams number 4. And you were asked some questions about this exhibit on redirect examination by the Honorable Ms. Love, and I'll show it to you. Okay?
Yes.
Well, with Mr. Kokomo's permission. You can't see it, Mr. Kokomo, if you could bring it down a little bit. Okay, thank you, sir. You see at the top of Mr. Williams number 4, the page 1698
Yes.
in blue?
Yes.
And from number 2 of Mr. Williams, 1603, that's approximately, I heard you say you're not good at math, I understand that, but it's approximately 95 pages of text between the two quotes, right?
Yes.
Okay, so this is a totally different day also. If you remember, and if you don't remember, we could go back to it. On Mr. Williams number 2, this is on February 4th of 2021, right? Mr. Williams number 2.
Yeah.
I could show it to you. Do you need to see it?
No.
Okay.
What
And-
they going over?
It's the same thing, yes, sir. And then on Mr. Williams number 4, this is now on the very top of it is February 6th, 2021, right?
Yeah.
Okay. And then, as the indictment says, the next line after on Mr. Williams number 7, we'll just start bringing me the money. You see that?
Yeah.
That's not until February 7th, what, about 100 pages later in the text messages, right? Or the chat messages, right?
Yeah.
Let me show it to you. Give me 1 second. I apologize. Tricia, what page? Let me do this. On page 1706, if you don't mind, Mr. Kokomo. Right in the center, just below center of that page. Do you see at time 1:00:20? Mr. Kokomo, if you could wrap your, you could circle it. Do you see that, Mr. Stephens?
Yes, yes.
Okay, and that's on page 1706. Right? That's more than 100 pages in chat later, right?
Yeah.
Does that have anything to do, that quote right there, you'll start bringing me money, really, does that have anything to do with what the prosecutors put in Overt Act number 2127 earlier about little Uzi Verts?
We didn't objection as to the point of the question. We did not have anything about Uzi Verts.
I stand the question.
Because part that is on the board, on your screen, they'll start bringing the money. If you go down a little more, Mr. Kokomo, bottom of that page, you see right there, man, y'all little hands, stop playing. You see that's the second last one?
Yeah.
Do those items, those words have anything to do with little Uzi Verts
Objection, Your Honor, again.
statement?
I stand the objection.
Does it have anything to do with what is written at the beginning, YSL rule the world? Is there anything to do with it?
All right, them two different conversations.
Objection to the commentary, right?
I stand it.
They're not even close in context. Context is a bad word. They're not even part of the same conversation, right?
No.
And Ms. Love started to read sections skipping around in Mr. Williams number 4 to you earlier today. You remember that?
Objection as to the compound nature of skipping around.
It's not a compound question.
I stand as the form
Do
question.
you remember the Honorable Ms. Love asking you about Mr. Williams number 4 and asking you about specific chats this morning? If you don't remember.
But she was right here reading with me.
Yeah.
Yeah.
You remember that?
Yeah.
And she was going out of sequence, right? With that, do you know what I'm?
Yeah, I know what you mean.
Okay.
I'm trying to remember what she reading like. Some she was reading directly right up on each other, and some she'll flip the page. So yeah.
Okay. Now, the chats that Mr. Williams is referring to that you were a part of in Mr. Williams number 7 and the number 4, and the jurors will have this.
Objection, Your Honor.
It's in
I
evidence.
stand the question.
This is in evidence. Mr. Williams is commenting on the fact that you were trying to raise money for rent, right?
Yeah.
Okay. Where in this chat or in anything in Mr. Williams number 2, is there anything criminal dealing with Mr. Williams?
I stand the question.
Where is there anything that furthers the interest of a RICO conspiracy in
I
Onion?
stand the question, Mr. Steele. Let's move on.
Now, Miss Love only asked you about Mr. Williams number 4, the one we were just talking about. It's on the screen, right?
Yeah.
She didn't mention Mr. Williams number 2 that I just showed you, right? Correct?
I think it was like 21 pages. That's what she showed me.
She didn't ask you anything about Mr.
No.
Uzi Vert, correct?
No.
That's Mr. Williams number 2 and 3. She didn't ask you about Mr. Williams number 7 at all, right?
Object as to the relevance of what I asked you.
I'll rule the objection.
Am I correct?
Yes.
She didn't ask you anything about that. Okay. Now, Ms. Love asked you over and over again about
Sure
Mr.
did.
Williams talking about God, being humble, truly humble unto God. You remember any of those type of questions?
Objection, Your Honor, to compound.
I stand the question.
Do you remember questions about that the prosecutor asked you about Mr. Williams being humble?
Yeah.
Do you remember questions that the prosecutor asked you about God? Mr. Williams talked about God.
Yeah.
Do you remember questions that the prosecutor asked you about truly humble under God? It's called just truly humble under God, thug. You remember those questions?
Yeah.
And she limited you to a song that is in existence in the public domain. You remember that? She kept asking about songs.
Your Honor, I object as to
I
characterization.
sustain the question.
Do you remember the prosecutor consistently saying for you to remember what song mentions humble or God? Do you remember that? Or truly humble under God? You remember that?
That was my understanding to remember a song that says something like God, to say a song that says something like God. And I choose that one because I remember that specific part in the beginning of the song. He was referring to God.
And you're talking about what's the meaning of life or whatever dropping jewels is?
Yes.
What Ms. Love didn't ask you about is whether Jeffrey ever gave any interviews, public interviews about the meaning of, did she?
Trying to get in self-serving.
I'm not asking about a statement.
Let me finish the question before I can move on. So what's your question, Mr. Steele?
Did Ms. Love ask you anything about Mr. Williams getting an interview or interviews in 2016, let's say, 8 years ago, about being humble and what it means that he doesn't want to be known as young thug? Did she ever ask you those questions?
Objection, compound.
I sustain this to form. Why don't you rephrase?
Okay. Did the prosecutor ask you any questions about Mr. Williams' statement, public statements about being humble?
Objection, Your Honor, as to
Basis.
any statements by the defendant would be self-serving, hearsay.
I sustain this.
I'm not asking a statement. I'm asking what Ms. Love answered.
I sustain the question, though. Form the question.
The judge doesn't want you to say what Mr. Williams said. Don't say what he said. Do you know of public interviews of Mr. Williams given concerning the topic of being humble?
Objection, one,
Basis.
it would be, again, he is attempting to refer to self-serving hearsay. It would be speculation as to what the defendant meant in the interview.
I sustain the question. Sustain the question.
Do you know, without saying what Mr. Williams said, because the judge is sustaining that, do you know Mr. Williams explaining anything in interviews?
Objection, Your Honor, as to anything about.
That's the same question 3 times, Mr. Steele. So
Do you-
move on to something else?
Do you know whether Mr. Williams has ever discussed, don't tell me what he discussed, that he does not want to be known as young thug, but it's what makes money?
That's been asked and answered. I'll sustain the question.
Okay. You know the song Let Me Live by Mr. Williams?
Your Honor, I would object to any reference to statements by the defendant offered by the defendant.
Overrule the objection. Can you answer that, sir?
Trayvon Martin's song?
Objection, Your Honor, as to what song.
Yeah.
You know that
he-
song?
He needs to finish it with, first maybe ask him if he knows the song.
Do you know that song?
I'm trying to think.
Take your time.
No.
If I played you the song in private, do you think that you can tell the court and the jury whether you recognize the song or not?
Yes.
Objection on 24-801.
I sustain the question.
Do you know whether Jeffrey Williams spends a tremendous amount of time when you're with him, when you speak with him on the phone, in a studio recording?
Yes.
Do you realize that Mr. Williams has thousands of songs that are not released?
Yes.
Do you realize that Mr. Williams has thousands of songs that have been stolen?
Objection, speculation.
If you know.
An objection basis before the answers.
I sustain this to form. Why don't you rephrase it?
Do you know whether Mr. Williams' art has been pirated or taken? If you know, if you don't know,
An
just say I don't know.
objection as to relevance as well.
I sustain the question.
Point being is Mr. Williams has a lot more songs recorded than what's in the public domain. True?
Yes.
Thousands more, right?
Yeah.
And do you know that Jeffrey Williams has songs under Jeffrey and not Young Thug? Do you realize that?
Yeah.
And do you know that those songs don't sell very well?
Objection, speculation.
If you know,
I sustain the question.
are you aware of that?
I don't know about sales for real.
All right. The prosecutor asked you about Sergio Kitchens. You know who I'm referring to?
Yeah.
Now, he is an world-renowned, if you know, known artist. True?
Yes.
And he goes by the stage name, what?
Gunna.
Gunna.
Yes.
Okay. And the prosecutor asked you whether he was a co-defendant, and a co-defendant means it's a human being. Defendant's just a kind of strips a person, but it means it's charged with a crime, right? It's,
I sustain the question.
you understand that it's the state of Georgia plaintiff versus Brian Steele defendant. I'd be the defendant. You understand that? That's where the word comes from? Okay.
Yeah.
And Mr. Kitchens is in this indictment an accused. You aware of that?
Yes.
Okay, a defendant, right?
Yes.
Okay. And Mr. Kitchens, if you're aware, resolved his case. True?
Excuse me.
Yes.
About a month before you did, right?
I don't remember. Wasn't what?
That's fine. And he was released from jail, right?
Yes.
And he pled Alford, meaning he maintained innocence, right?
On speculation
This is-
is relevant.
I sustain the
It's
question.
on the indictment.
No, but I sustain the question.
All right. Now, do you know what an Alford plea is?
Objection, Your Honor.
I sustain the question.
I'm asking the witness if he knows.
I sustain the question.
Okay. All right. Now, I want to talk with you.
I would love for them to ask the opposing counsel if they know what that means.
About Gunna or Mr. Kitchens. The prosecution keeps calling you the leader or the beginner or the creator of YSL, one of them. You realize that?
Yes.
You and Jeffrey and a man named Walter Murphy known as DK, right?
Yeah.
That's what they're saying. And tell the jurors what crime that you know that Sergio Kitchens ever committed to further the interests of the criminal street gang YSL.
I object, and I'd ask you to
Basis.
vote.
Okay, all right, come on up.
So now we don't want information about pleas coming in. Because Walter Murphy also took a plea. Sergio Kitchens took an Alford plea. I forget exactly what Walter Murphy took a plea to. But look, now we don't want plea deals being discussed. Isn't that interesting? Isn't that interesting? She's so quick to oppose that. Also, Jenny, thank you so much. Gifting 5 memberships here. Make sure you guys are showing Jenny some love in the chat. Saying thank you if you got a gifted membership. Turning green and growing the gang. Yeah, she says you've been slimed. But just crazy, just crazy. Now we have a problem with plea deals. Memphis Most Wanted, do you remember what day of the trial those gun experts testified? There were a few different ones. Are you thinking in relation to Waters Road and what was her name? I mean, that all would have been in like the day 150s, 160s. Angela, there was a woman who she became a school teacher. She said she was a school teacher when she was testifying, but she's the one that did the analysis on the FN firearm and some of the shell casings that Kevin Leonpacher gathered the day after all the other casings were gathered from Waters Road. And they turned that in like a few months after the other stuff was turned over to GBI. That was like day like 159, 160, something like that. And then this, you might also be thinking of the gunshot residue guy that, right? I'm trying to picture who you're it was a great witness for the defense. They all were great witnesses for the defense. But I think one of them also testified to the lining of the vehicle coming back negative for gunshot residue. So, but those were times, and I think a lot of those weren't Love doing the questioning, but I do want to put together something more in depth on Waters Road. We started this off by looking at Love argue some evidentiary issues where she made that like, because they removed everything from the house before they came back, when she was arguing during one of the days with Whitaker with Max Shard. I think it was like day like 140 something. Well, lo and behold, that same day, this was like 2 weekends ago, I just went down a rabbit hole and looked at all that stuff from Waters Road, and it's more sketchy to me than it ever was before. But it's not all Love, so I won't fit that into Love-a-Palooza. But maybe if we do like a what was the mess around everything from the riddled with bullets, Darius Ford, Christian McMiller, 911 call, shooting, till the end of the investigation into the Chamel Drinks shooting, and piece that all together with all of the shenanigans would be great. So I want to say the one GBI there, I think there was a Sarah and there was an Angela. Angela Camp, formerly Angela North before she married. That's the one that's now a teacher. See, Alan Glover, Mark Campbell, that was one of the officers. Taisha was Polka. Detective Starks. I think that was the guy that helped with the arrest warrant, looking at the Audi. What other witnesses? Yeah, and then I'm just getting back to Leonpacher. So I don't know the name of the other witness. I'll have to look. Yeah, but that was a whole time. That was a whole time. And big thank you again to Jenny. Let's skip the approach. We'll watch them walk up. Way up there.
Okay.
Dick is so used to walking in and out.
Mr. Stephens, tell the ladies and gentlemen of the jury, based upon your own personal knowledge, whether Mr. Kitchens or Gunner ever committed a crime to promote YSL.
Objection, Your Honor, compound.
Tell the ladies and gentlemen of the jury whether Mr. Kitchens ever committed a crime to promote the gang YSL.
Your Honor, he asked the exact same question, so it's still a compound question, so not objection. There are two questions.
I sustain the question.
What did Mr. I'm sorry.
Go ahead, sir.
What did Mr. Kitchens do, if anything, to benefit a criminal street gang YSL? Tell them.
I object on the grounds that I mentioned at the bench, and I also object on the basis that
I'll sustain this other question. Mr. Steele, why don't you ask them one question to begin with, and then based upon that, if he answers anything, then we'll take it from there.
Do you know if Mr. Kitchens committing any crime to benefit your gang?
objection, Judge.
I'm asking a single
Judge,
question.
he's asking a compound question.
No, he's not. Not in this one. I'm staying the question. I mean, I'll rule the question. Let him ask that in that last one.
And I'd ask for a basis for his knowledge.
Go ahead, Mr. Steve.
I don't have any knowledge.
All right. Okay.
Now, I want to talk with you about, and if the state can help me, if you are able. I believe that's 20 UD. Mr. Stephens, it'll come up on the screen when the Honorable Prosecutor puts it up, and I thank her for doing that very much.
Mr. Kearns, would you let us see?
And thank you, Miss. Thank you so much. Mr. Stephens, if I can go through this photograph with you and the letters at the bottom, if that's okay with you, okay?
Yes.
Okay. First of all, do you recall where this photograph was taken, best to your memory?
No.
Okay. Is it fair to say, if you remember, this was what's called a pose photograph, meaning you know it's the camera is taking your picture, you're smiling towards the camera. Is that true?
Yes.
Okay. And behind you, it appears to be, I see 3 different vehicles. Is that what you see in the 27 UB?
Yes.
Okay. And the far vehicle in the top left is a SUV. Is that fair to say?
Yes.
And then there's a vehicle next to that one, correct?
Yes.
And then you are seated in a chair right in front of a blue vehicle, right?
Yes.
Is that a Rolls Royce?
Yes.
And whose Rolls Royce is that?
Mr. Williams?
And did he give that to you?
No.
Okay. Now you are seated, and if you can blow it up if you don't mind when you get a chance, maybe on the neck area of Mr. Stephens. Mr. Stephens, you see the Honorable Prosecutor blowing this up for you?
Yes.
All right. And I'm focused on, it looks to me like there's 2 chains. Is that fair to say?
Yes.
And one of them is a traditional, very strong, powerful cross. Is that right?
Yes.
Did Mr. Williams give you that cross?
No.
Did Mr. Williams give you the chain that cross is on?
No.
How about the next? You have something that I believe says a name. Is that right?
Yes.
What name is that?
Mine, Slug?
Okay. And did Mr. Williams give you that jewel?
No.
And did he give you the chain?
No.
Okay. Then if you don't mind, if you can scroll in on the left hand. That's fine. I appreciate it. Do you see what the Honorable Prosecutor tried to get enlarged as much as possible? Your left wrist?
Yes.
And that is a Rolex watch, correct?
Yes.
And it's worth approximately $5,000?
Yes.
And that was given to you by Mr. Williams
Yes.
as a gift?
A birthday gift?
Birthday gift?
Yeah.
Okay. Did you do anything for Mr. Williams to promote some sort of criminal activity in exchange for that birthday gift?
No.
Did Mr. Williams give it to you and then tell you, I'm ordering you to go commit this crime on behalf of YSL? Did that happen?
Hearsay and self-serving.
I sustain the question.
Did Mr. Williams give that to you with any type of strings attached? That may be a bad way to say it.
Objection.
Did you do
I'll sustain this to form. Go
did you
ahead.
do anything for Mr. Williams in exchange for that gift?
Gave it to him because I was born on my birthday.
It was a birthday present.
Right.
All right. Now, if you can go to the right wrist, do you see that I believe you're wearing what I call a chain on that right wrist? Do you see that? And if I'm wrong, just say I'm wrong.
You wrong?
Okay, that's just part of the fabric.
That's not jewelry.
Not jewelry. Okay, nothing to do with Mr. Williams.
No.
Okay, then if we can go up a little bit. Actually, down a little bit. And you see that writing?
Yes.
Okay. And this was in the first line that there's words. This was like by I am underscore little git and 1,181 others, right?
Yeah.
And this on Instagram. Is that fair to say?
Yeah.
Okay. And then what you wrote is underscore one slug, bust down Rolly, came from Thug, me and Mr. Williams, right?
Yeah.
You know it's real.
Yeah.
Real or real love or whatever little baby said, right?
Yeah.
And what does that mean? Whatever. Well, who is little baby?
Entertainer.
Okay. Is he a musical entertainer?
Yes.
And people would say a rap, anything? Gangster rap?
Entertainer.
Okay.
Yeah, not so.
And what does it mean? If you remember, what did you mean by whatever little baby said?
I think that was one of his lyrics in his song.
Okay. That's a song, right?
Yes.
Okay. Is there anything in State's Exhibit number, and they said 27, you, little B as in Barry or Bravo, anything in there that's connected to somehow a criminal conspiracy RICO count?
Objection, Your Honor. That is a matter of jurisdiction.
He's right here. Question. Did you post this in any way that is criminal activity?
Your Honor, objection. As to the same
This is
basis.
this is his posting.
Jury is.
I'll rule the objection. Can you answer the question?
Is this in any way affiliated with criminal activity?
Your Honor, that objection, because that is a matter that you arguing.
I'll sustain the question.
Is State's Exhibit number 27 UB have anything to do with a crime and Jeffrey Williams?
Mr. Steele, I've sustained the objection. Please don't ask it again, please.
He just marches and puts the paper down.
Now, the prosecutor asked you today that after Jeffrey became famous, you went separate ways. You remember something like that?
My bad. Yeah, she had me a lot of questions. My bad.
Actually, Jeffrey spent a lot of time working, didn't he? Before he became famous.
Yes.
And prosecutor asked you, why didn't you spend that much time? You already explained that to the jury, right?
I did.
Basis.
Arguing or asking a question she wasn't, I didn't ask that. Mr. President.
I'll rule the objection. Can you answer the question?
You didn't.
Yeah, I answered. I told her I didn't have no talent.
And that's very, modest of you. Modest means polite of you to say you didn't have the talent, but you also didn't put in the time with Jeffrey, right?
No, I ain't putting no time.
You were doing other things while he was working, right?
Yes.
That's what you said earlier on your cross-examination, right?
Yeah.
Nothing about when Jeffrey became famous. That's how Jeffrey, he went for something, right?
Yeah.
You told the jury it was amazing. It was your word.
Your Honor, I'm going to object if he's already
Basis.
asked an answer.
I'll sustain the question.
All right. State's Exhibit number 16U, it might be in front of you. Is that what the number is, if you don't mind helping me out, Mr. Stephens?
Yes.
Now, you were answering all the questions asked by the Honorable District Attorney Hilton. Remember that?
Yeah.
And you were put under oath, right?
Yeah.
And the Honorable Judge Glanville, Chief Judge Glanville, he was here asking you questions as well. He was present, right?
Yes.
Where in that document or in the video does it ever say that Jeffrey Williams was part of a criminal street gang? Tell the jurors.
They don't.
I'm sorry?
They don't.
So you were under oath, having to answer all the questions of the prosecutor, and they didn't ask you that question.
Ain't in there. No. I didn't get asked that.
I can't hear you.
I didn't get asked that question.
Was Jeffrey Williams part of any criminal street gang whatsoever, sir? To your knowledge, as charged in YSL, RICO count, or any other gang activity
Objection,
here?
Your Honor, compound.
I sustain the question as a form.
You were asked about YSL, and the prosecutor Love asked you, are there Crips in YSL? You remember that?
Yes.
And are there Bloods in YSL? She asked you. Remember that?
She had me a lot of questions.
That's fine. If you don't remember, it's fine. Or maybe I'm wrong. Okay. I want to talk to you about Jeffrey Williams, YSL. Okay?
Yeah.
Young Slime Life. That's a record label. You know that, right?
Yes.
And are you familiar? And if you're not, just say, Brian, I don't know. Okay? Does YSL produce music?
Yes.
Does YSL record label distribute music for public consumption? Consumption means for the public to listen to.
Yes.
Does YSL include music engineers?
Yes.
Does YSL include lawyers, business lawyers?
Yes.
Does YSL have managers?
Yes.
Do they have bookkeepers? That means people who keep all the money.
I mean, they got to it. That's a business.
If you don't know,
Yeah.
okay. Do you know if YSL pays taxes?
Yes.
Do you know whether they're registered company in the state of Georgia?
Yes.
Do you know whether they were bought out by a publicly internationally?
Isn't that funny? And yet there's no financials. They don't look at the financials. They just take a or group chat. All the social media they looked at. They didn't look at Lil Uzi. They didn't look at the stuff that would show that Lil Uzi Vert had the diamond in his head. But They talk about 24 M's. That's as far as they go with financials in this case. But they could have gotten tax records. They could have looked at business registrations, and they don't. They don't.
Traded company.
Your Honor, that's what basis I object.
Do you know that?
For his knowledge.
It's public information if you know.
I sustain the question. It's been asked and answered to Mr. Steele.
Do you know whether this record label that Jeffrey created, if he's a part of it?
Yes,
And are there people who do promotion and advertising
yes,
and search for new artists, A&R,
yes,
and people who promote interest in Young Thug brand?
yes,
And Young Thug brand is something that you don't back down, no fear. That's what was created, right?
Objection, that's just speculation.
If you know.
I sustain the question.
In the public domain, that's what Young Thug brand is, right?
Objection, yes, that same
I
basic
sustain the
speculation.
question.
I would like Mr. Kokomo, with his permission and the court's permission, to show privately Mr. Stephens that song, Let Me Live, to see if he knows the song, Your Honor.
Your Honor, I object.
I sustain the question.
Okay. Did Jeffrey ever give you anything in order to enable the stature or the respect or the benefit of any gang?
Objection, Your Honor.
Did he ever give you
I
anything?
sustain. Mr. Steele, it's getting to the point, it's asked and answered at this point as well.
Now, in Mr. Williams number 4, the chat that's in evidence,
yeah,
there were talk about, if you need to see it, we can put it up and hand it to you, okay? There was talk about Mr. Williams saying, I'm on this thread. Don't play with me. I'm a real gangster, for real, for real. Don't talk like that behind my back because I'm here. You remember all those conversations? And Mr. Williams said, I pay for everything. Remember all that?
yes,
Does Mr. Williams pay for the $1,500 rent that you were trying to raise?
no,
And when Mr. Williams wrote, he pays for everything, if you go out with him, he'll pay for you, right? At a club.
yes,
True? At the studio, dinner, drinks, right?
yes,
Is Mr. Williams funding criminal activity that you're aware of?
Objection.
I sustain the question.
He would know.
Sustain the question.
Okay. Your Honor, may I have just a second?
You may, sir.
Your Honor, is Odyssey up? Because I was told, do
It's not.
you have the dates?
We cannot have that. And I have no-
Mr. Stephens, the prosecutor was asking whether I visited you in a jail. Remember those questions?
yes,
I asked them for the dates.
Objection, Your Honor, as to Mr. Steele talking about anything, conversation outside of Mr. Stevens' presence in his direct or cross with Mr. Stevens.
What's the base for your objection, Madam?
Improper question.
I sustain the question.
No date was given.
Objection, Your Honor, he's testifying.
I sustain the question.
Have I ever represented you on anything?
no,
Do we have any type of relationship, attorney-client wise?
no,
Do you know that I've defended Jeffrey in other cases for 8 to 10 years?
yes,
Do you know that Jeffrey's put my name in songs?
yes,
Do you know whether you called me because you know I'm a lawyer in Atlanta?
yes.
Did that have anything to do with Jeffrey Williams?
No, I was just trying to get somebody to represent me for my probation revocation.
Oh, love that. Love that. Guess what he just got in front of the jury? Hey, the state does, in fact, try to revoke probation from us. That thing that they have this leverage over us when we take a plea deal to testify here right now.
Except for those other items, I don't have anything else.
Okay. State anything further?
No, Your Honor, no further questions.
All right. Anybody else? All right. May we excuse Mr. Stephens permanently or temporarily?
Permanently for the state's note.
Your Honor.
Sir?
Not holding it temporarily based upon the Odyssey and the other matter, according to the state. So I don't want to do it. But it's free vote. Not holding.
Can you all approach for a second, please? Mr. Stephens?
All right, so that's the end of that one there. And now we're going to go over to something involving, it's Christian Atkins. It's going to make arguments on day 22, and it comes back for a little bit on day 23. In between, we have a bunch of police officer witnesses that are testifying to some, the morning of day 22 is like about Christian Eppinger and unrelated to stuff involving Jeffrey Williams. But later they get into these Sergio Kitchens, that's Gunna, and Jeffrey Williams, Young Thug traffic stop from like 2017, where they end up finding cash and drugs in the car. Keith Adams pretty much gets it in front of the jury that the items were found. They took like $40,000 from Jeffrey Williams in cash. That's what they took off of Jeffrey Williams' person. But the contraband materials were actually located with the person in the back seat who's not named in this indictment. So Adams demolishes that. But as context there, that's one of the fewer things that the state argues Jeffrey Williams actually had a direct role in this indictment. And even though Love isn't the one doing the questioning, I swear she commanded this argument. They wanted to state that another vehicle pulled over later that had guns in the vehicle was somehow related to Jeffrey Williams. So we're going to watch Atkins argue for the admissibility of this photograph of a different car. Let me get the timestamp. And I'm sure you guys, is anybody surprised that that's an issue? That that's something we're going to hear argued in this case? But after watching all of this, I feel like Love ends up putting Atkins up to this. Watch her body language as we go through this. We'll slow it down because it's Atkins, I think, speaks a little faster. If it's too slow, let me know. We'll speed it up. We'll have the volume.
I appreciate it. Okay. So,
Thank you.
all right. Mr. Adams, and anything, sir?
Yes. I don't know when this is going to come up, but just so we don't put ourselves in a position of having jury sit there for another 15, 20 minutes, or set them out again. We've received some potential exhibits from the state that I believe they're going to try and introduce.
What witness are they going to be attempted to be introduced through?
I believe through Officer Fikes. Am I correct about that?
That is correct, and Officer Gant will also reference them, but initially introduced through Officer Fikes, Your Honor.
All right, and I'm going to pass these up to the court, but these exhibits and the testimony that's going to be surrounding these exhibits are issues that the court has ruled on before. You may recall that Officer Fikes and Gant are involved in a 2017 stop of a car. That's what we're talking about right now with this officer. In 2018, there was a traffic stop, a speeding stop made by Lieutenant, I think is what he is now, Lieutenant Gant. He stopped a Porsche that was being driven by Mr. Williams, and Mr. Kitchens was a passenger in that car. There was another car that was behind that Porsche, I believe a Charger maybe, with other individuals in it. That car was stopped as well. And you might recall this fact pattern. Mr. Williams ultimately was released with a speeding ticket. And
Yeah, I heard him. I think we heard a motion on that. In fact, I know we did.
we did,
Yeah.
we did.
Okay,
And the individuals in the vehicle behind that car were investigated. I think Fikes dealt with them. Gant dealt with primarily Mr. Williams and Mr. Kitchens. There's some weapons and some drugs and some guns and some money that's found in that car, the second car, the Charger, where there is no connection shown to Mr. Williams, other than that the cars appear to have been traveling one behind the other.
That's been the allegation all along.
Right, and I think the state referenced that, or an officer referenced that before Mr. Williams left, because he was allowed to leave after he got his speeding ticket, he asked what's happened to the people in that car, and the response was something along the lines of, we found some marijuana, so we're going to deal with that. You can go on your way.
Okay.
He leaves and he goes on his
I remember all that.
Right. And at that time, Mrs. Steele was arguing a motion, and I believe there was a discussion about the admissibility of the evidence. And if I can just step to Ms. Weaver and pass her the exhibits. Stop talking so she can do that. That the state wants to introduce. Those are pictures of the items that were found in the second car. Those are the items that Mr. Steele argued and asked the court to keep out, that they're not relevant to the charges either against the speeding ticket against Mr. Williams, or for that matter, this case. There's no connection to either one. And Your Honor indicated, and I don't have a copy of the order in front of me, but Your Honor indicated that you would keep those out. Those would be kept out unless the state were able to show some kind of connection between those items and Mr. Williams. So that was the court's position. That was the court's ruling. And so I'm a bit, I don't want to I was going to say flabbergasted. I'm a bit surprised that the state is actually intending to ask this officer about those items that the court has already indicated have no relevance to this case unless they make some kind of connection. They haven't made that connection. And we have not received any evidence to indicate that they will or can make that connection. So I'm asking you to enforce the ruling that you made previously.
Well, I hadn't ruled on it yet. Mr. Adams, thank you for refreshing my recollection and memory as to that particular motion. What I have for purposes of just our academic discussion are labeled 1X, 2X, 3X, 4X, and 5X. So were these the items that were taken from the first vehicle involving Mr. Williams, or the second vehicle that was the second vehicle?
Your Honor, these are
that
from
was eventually stopped.
second
The
vehicle.
second vehicle. All right. Okay. So,
May I respond, Your Honor?
okay. What's the nexus of those two? Because from the defense's position, I think we had this issue to begin with, is that clearly anything that was found in the stop of Mr. Williams or that first vehicle would be relevant. These guns and money and that are purported to be shown through 1X through 5X, what's the nexus of or relevance of their admissibility?
So, Your Honor, to answer the court's question, and I wanted to be clear, this is Act 75 in the indictment, where it says on May 18th of 2018, defendant Jeffrey Williams, an associate of YSL, was the subject of a traffic stop for speeding. Involved in the stop were two vehicles, one being driven by Williams and another vehicle closely following Williams, containing 4 individuals who were armed with numerous weapons with high-capacity magazines, to include an AK-47 with a 30-round magazine, an overt act in furtherance of the conspiracy. And, Your Honor, I think this is very important, because when we were discussing whether the Arkillian-Bennett Act could be admitted as an intrinsic.
I'm sorry, I interrupt you.
Yes, Your Honor.
Which act is it?
Act 75 in the indictment, Your Honor, which
75?
is page 34.
Okay, 75?
Yes, Your Honor. I'm letting.
All right, okay, go ahead.
So, Your Honor, the state defense's position is that the state can't be able to try. This is all for argument at closing argument. If they feel like the state doesn't create a nexus with Jeffrey Williams or does create, they can argue that at closing. The state, in any case, until all the evidence is complete, has to prove beyond a reasonable doubt all of the cases in indictment. In this case, this is an overt act in count 1, the RICO conspiracy. So this is an overt act that the state is putting forth evidence to present to the court for the jury. And so the defense wants the state to be precluded from introducing evidence that is in the indictment that was presented to the grand jury, and the state has, and its weight not admissibility, Your Honor. They may feel that the state's evidence is weak, the state's evidence is non-existent, or they may think the evidence is strong, but will argue against it otherwise. But that's all for them to decide as advocates and to argue to the jury. The jury has to decide whether the evidence that the state presents is sufficient or insufficient to the standards and the law instructed by this court when they are deliberating, determining if overt acts have been admitted or completed by what the state alleged in this indictment. And if the overt acts go to prove count 1, that is all within the purview of the jury. And that is the state's argument, is that this is verbatim, and in the way it's worded in Act 75, it addresses what the state is putting evidence forward to prove.
Your Honor, if I may.
Sir.
This is why we have pretrial hearings before the case moves forward. We have a pretrial hearing on this, and the court has the ability to make a determination if there is evidence that is relevant or not relevant, or admissible or not admissible, for a variety of different reasons. In this case, we had a motion, and there was a discussion of this previously. The court had an opportunity to examine whether or not, exactly what we're talking about, whether or not there's any nexus between in this stop that's being alleged as part of Act 75, whether or not there's any nexus between the second vehicle that was behind Mr. Williams and Mr. Williams. And the argument that was put forth and the argument that the court evaluated, and I believe based on the court's ruling or position at that point, was that unless they can show a connection between one and the other, then it's simply not admissible. What this amounts to, I mean, what is the connection? Mr. Williams is in one vehicle, he's charged with speeding, he's released. There are other individuals, and there's not been and there will not be any nexus that they can possibly show connecting anything in that second vehicle to Mr. Williams. What are they gonna? They're gonna say, well, he said what's happened to those people over there? That's the nexus. That means that they're involved in any sort of criminal activity. It's simply not there. And this is not a new issue. We've discussed this before.
I understand that. I think I defer ruling on it to, in fact, I know I defer ruling on it to hear more about it, and I'd make a ruling once I've heard it, once I was in a position to do so. That's why I deferred ruling on at that point in time. But yes, Mr. Atkins.
Yeah, Your Honor, the state feels that absent a general or special demur, which this court has heard, this is like saying that the state presents a case of murder to the grand jury, and a defense attorney comes up and says the state shouldn't be able to they need to articulate to the court why we have to present evidence of an armed robbery, of a murder, any charge. This is an overt act in the indictment. And so defense counsel's argument is juxtaposing two different legal principles. The state has to present evidence and is intending to present evidence through the testimony of Officer Fikes and Officer Gant about this stop, and the totality of the evidence in this case during the timeline in this indictment of when the RICO enterprise was going on, all of that, it all plays off one another. And so this is an overt act that the state has put forward to prove this RICO, and the state should be wholeheartedly allowed to present evidence for an overt act in this very indictment that we're in trial for. And
that's the crux of the matter. And I will respectfully suggest to my esteemed opponent on the other side that there's a difference between a demurrer and evidence. A demurrer deals with language in the indictment. That's not what we're talking about. We're talking about evidence and the appropriateness or the admissibility of evidence. And so, excuse me, we're allowed to challenge whether evidence, you can have anything in the indictment, and the court can make a decision that there's certain evidence that's simply inadmissible. It's not appropriate, it's hearsay, it is for whatever reason. And that's what we're dealing with. And however their case goes forward, when the court makes a ruling on that evidence, they've got to deal with it. But the central issue here is whether or not the court deferred, but for them to maybe make a showing that there's some connection. So the question I would have is, well, what is it showing? What is the new evidence? What is something new that they can present to the court that shows that there is some connection between the items found in a car that is not connected to Jeffrey Williams and Jeffrey Williams?
Okay. Sir, anything else?
Your Honor, the state's position is that, and defense counsel has referenced the court ruling. I don't know if there's a copy or a date.
I haven't ruled yet. I deferred on the issue of whether or not I would admit anything that was found in the second vehicle until such time as I heard more evidence. So who's in the second vehicle? I remember that there were who were the four people that supposedly in the second vehicle?
Your Honor, I will get their names. They are not indicted co-defendants. Give me one brief moment, Your Honor. And the state, and this is why, Your Honor.
Okay, well,
yes, Your Honor.
I will give you slow up.
I will give you their names in one moment, Your Honor.
Get them too.
Your Honor, their names are Leonard Gay, Jonathan Carlay, Levi Atkinson, and Marquise Pryor. And I'm happy to spell their names for the court if the court would like. Those are the four gentlemen in that car. The state also has lyrics from Jeffrey Williams that says he has snipers behind him. And Officer Gant's testimony is that these two cars were rolling in tandem together, and there's statements made referencing the connection between them. And this is also roughly 6 months after Officer Fikes pulls over the Maybach vehicle that he's not complete testifying about. And it's the state's position, and can make an argument, and defense can argue otherwise, that the defendant's actions in the way that he operates or navigates has changed. Now that in this 2018 stop, the high capacity magazines, the 30 round extended clips and the Kel-Tex and everything else found in the car from Officer Gant and Officer Fikes is in this trail vehicle. And Mr. Williams asked if they need a ride, and it's the totality of how this evidence, firearms, all of the overt acts, none of them are looked at in isolation. And Your Honor, the state, speaking of evidence, if the defense is saying that is this evidence relevant, it's certainly relevant to prove an overt act in this indictment. That the state always has to present evidence for an overt act. So I don't know what evidentiary objection the state is making, other than saying they don't want this to come in or they think it's weak. That's why we have trials, so the jury determines if this overt act or this count, because ultimately this relates right back to count one.
Well, the defense is saying that the nexus, there's no nexus. Like, for example, if you had 4 YSL members or gang members in the second vehicle, one of them was in there, and you were trying to show that either membership or the other things that you are trying to allege in the indictment, that would be appropriate. And the way it's charged as well is it's 4 individuals. So, you know, which 4? That's why I was waiting to see which, or the nexus as to the 4 individuals, because just because 2 cars are traveling down the road at the same time doesn't necessarily make them tied to one another. So how are you, other than the fact that they're traveling together, there was no evidence or nothing, no statement saying, hey, other than Mr. Williams saying, what's going to happen to the other people? That's the only thing I heard in the motion. Mr. Williams inquiring about what was going to happen to the other people in the second vehicle.
Your Honor, in the facts as Officer Gant and Officer Fikes just conducting this traffic stop, but what is the reason that this is very important, that this is an indicted overt act, is because it's all of the facts and circumstances. And that's why it's not just this traffic stop in isolation. It's not as if the state charged a defendant with possessing these guns in a different car. It's charged exactly how the testimony is going to come out, and of exactly what is in overt act 75. And so the totality of Instagram, social media, all of the other overt acts, the indicted acts, the association, the connection, this total case, the jury can choose, not choose, or make any inference they want, an argument of a nexus to, and if this was in furtherance of the RICO or if it was not.
That's why I defer ruling on it, because the pictures here, I also have to as you know, balance 403. It's really, really prejudicial, and its probative value may outweigh it unless it's got some nexus. I mean, because these are pictures of automatic weapons and cash. So at this point in time, I don't see it. Not that I may not see it, but I don't think you've got it. You've got it at this point in time. There's been nothing else that connects other than testimony I've heard that, hey, Mr. Williams asking about these people from the other vehicle, but there's been nothing else that I've heard thus far that would tie these particular weapons to Mr. Williams as of yet.
So understand, Your Honor, would the state be able to brief this honorable court specifically on this issue first thing tomorrow morning?
We had a motion on this, okay?
Yes, Your Honor.
We had a motion. All right, I'm kind of inundated with law. I don't want to replow the ground again, Mr. Atkins. I'm waiting on the state to provide a nexus. That's what you all said you were going to do. So at this point in time, until you can provide a nexus, I'm not going to allow it. I now allow it. I mean, you can attempt to identify them or whatever else, but they're not admissible at this point in time. Because as I just mentioned, the court's fear is that without anything kind of tying or kind of just further substantiating this, that they're in a 403 analysis, they're going to be more prejudicial than probative. So, and I haven't heard anything yet. That's why I'm telling you that.
Hey, Amber, who is streaming the hearing where Prosecutor Lally is on the stand right now?
I don't believe I would probably, at this point, would admit them.
Yes, Your Honor. And so to be in line, the state will provide and what I was going to say, Your Honor, is that with this court's ruling, essentially the state is precluded at this current moment until presents the court to satisfactory reason of the nexus from introducing any evidence on overt act 75 in this indictment through the testimony of Officer Gant or Officer Fikes.
In terms of what's in the second vehicle. I mean, theoretically, you could. Hold on now. Does it go to any other count?
It's just count one, Your Honor, and overt act 75. That references this specific 2018 traffic stop with Officer Fikes and Officer Gant.
What is he?
All right, Amber, I'm looking for a feed, but it looks like they're on break. Like there's no judge in the seat over on the Young Jerks channel. But you guys know I love seeing a prosecutor get questioned. Oh, how badly I wish Love had to take the stand in this trial. And this is like the Miles King case, right? That Prosecutor Lally has to testify in, I think. So we'll call it that for now. So that's in the chat. Just want to make sure they don't come back and continue arguing here. I don't think they really do.
I'm inclined to. I'll need to, of course, keep these copies for the record. This is 1X25X for the time being. Like I said, at this point, without anything more, I would not admit them at this point.
Your Honor, in terms of witnesses availability at this current time, the state has just.
All right, so they decline it, but then, and I think you guys got I think you picked up what I was putting down about why I think Love made Atkins fight for this admissibility. Again, it was included in the indictment. There was a lot of talk back and forth. Well, if we go to the next day, if we go to day 23, and let me cue it up. I think it was like 20 minutes in. Look what happens the next day. Do you think Atkins did this on his own?
Hell of a time for a freak accident.
What?
All right, thanks, sir. Yes, all right, thanks. Thank you, folks.
Okay, so Mr. Atkins, who do you have? Do you have Officer Fikes outside?
That is correct, Your Honor.
Okay, all right. Any further issue before I go ahead and call in Officer Fikes and our jurors?
Your Honor, one matter I wanted to discuss. Defense counsel, Mr. Adams, was kind enough to share with the state some body cam that possibly defense could introduce related to the 2018 stop. Per the court's guidance, the state's direct of Officer Fikes is not going to address or discuss anything related to that. It's going to specifically be about what we discussed yesterday. The state, I imagine that that the defense counsel with those addressing a stop that we are not getting into, that, neither side will inquire of Officer Fikes about something that we're precluded from introducing.
Does Officer Fikes know that?
He knows that I'm not going to be asking him anything related to that stop.
The 18 stop.
Correct, Your Honor. At this time.
All right. You done, Mr. Atkins?
Yes, Your Honor.
Okay, all right. Mr. Adams?
Thank you, Judge, thank you. I think we need to be clear that the issue that we discussed yesterday has to do with evidence, specifically contraband that was found in the back of the Charger, the second vehicle. We did not say that testimony in regards to the 2018 stop itself was improper, was inappropriate. In 2018, and they had Officer Gant here yesterday. Officer Gant is the person who performed the stop in 2018 on Mr. Williams's car, and it was our position that that's fair game. That's fine. He was charged with speeding in that regard. But what the court specifically dealt with was whether or not the guns, the money, and the marijuana that were found in the second car was admissible evidence, was anything we could get into. And then court indicated that absent a further showing of some nexus connection by the state, that we couldn't get into that. Now,
so what is it you want to get into, Mr. Atkins?
well, I'm just saying that I want to make sure we're not improperly narrowing the scope of our inquiry. Officer Fikes was involved in that second stop. Officer Fikes had some conversation with Officer Gant. I will be candid with the court. What I've shared with the prosecutors is something that arose in the hearing with Gant previously, which is there's a period of time where Officer Fikes goes up to Officer Gant and specifically tells him to mute his body cam.
Yeah, I remember that.
It's like a minute long. He says, "Are you on or are you hot?"
Yeah.
The officer. Anyway, that to us goes to the credibility of Officer Fikes and doesn't have anything to do with the contraband. There's another portion of the video where Officer Fikes says to Officer Gant, where he goes to Officer Gant, and Officer Gant, they're talking about the fact that Mr. Williams is going to be charged with speeding. And Officer Fikes tries to get Officer Gant to up the charges to reckless driving. He says, if you charge him with reckless driving, we can go in the car. And so to us, that goes to the credibility of Officer Fikes because the evidence is an officer attempting to.
I don't have any disagreement with saying those two.
Right.
So anything else?
No, because I don't think that opens the door to
All right,
anything.
well, I was just about to say that. Now, all of you are very skilled examiners, but even the best of us tend to inadvertently do things we're not supposed to. But I'm just going to tell you with that caution, if you get into or open the door as to anything else by your examination, I may change my ruling. Okay.
I understand.
All right. So that's just the caveat that in the most dangerous game. Okay.
No, I understand.
Okay, all right.
And I'm being
Okay.
very candid with the court and
I appreciate
them
that.
in terms of what I intend to get into.
I do.
And that specifically doesn't go to anything regarding the contraband in car number 2.
Okay.
All right.
Your Honor, if I may.
Yes, sir.
Officer Fikes, in
Show love.
Officer Fikes' testimony, Officer Gant informed Officer Fikes to specifically, his first interaction, like if Officer Fikes is asked a question about 2018, his first interaction was literally walking up to that Charger and seeing the firearms. And so the state's position is that if Officer Fikes Officer Fikes' involvement was overwhelmingly involved with that Dodge Charger. That's why Officer Gant took the warrants out and handled primarily the Porsche. Officer Fikes' initial encounter was approaching the car and seeing these firearms, and that all is kind of part and parcel of Officer Fikes' involvement. So the state is intentionally not trying to get anywhere close to opening or asking Fikes any questions about the 2018 to not run afoul of this court's guidance on that. And the state doesn't feel that if on cross-examination he's asked questions about this stop, that there's any way to discuss that without, on state's redirect, the facts and circumstances of how Fikes is involved, who he interacted with, what he saw. Because if you just take in a vacuum a statement he made, it's relevant. Why is he on scene? What did he do? And his primary role was being quite alarmed when he saw a weapon in that vehicle. And so his whole interaction, everything he does with that stop is wrapped into the Charger. So the state just wanted to be clear with the court that I cannot envision questioning on Officer Fikes about a stop when he can't discuss the majority of his involvement and how he even got to that location, which was specifically to help Gant, because Gant was going to pull over the Porsche, and Officer Fikes' initial role was he needed help because there was 2 cars in tandem. And so Officer Fikes he's going to testify truthfully about what he did. He's going to talk about the Charger. And so the state feels that either the 2018 stop should not be discussed or it all should come in, because there is not, with the way that the facts and evidence are in this case and his involvement, there is not a way, and the rule of completeness, because if they're talking to him about something he did 30, 40 minutes into the stop, the jury is going to have no awareness, and it's fair to complete the story so the jury's not misinformed of how did Fikes even get to this scene? Why is he even here? Why is he talking to Officer Gant? How did he even get here? And he's talking to Officer Gant after he goes to the Charger. And their analysis or investigative steps, or if the defense was crossing him about what they just referenced, the way he's thinking about things is all under the lens of just witnessing these firearms in a car. And he mentions the driver's foot was fidgety. And so it's all wrapped together in why he's coming to Gant, his whole viewpoint of the stop. And so the state just wanted to be clear with the court to make sure the court's guidance, because the state doesn't feel that there is a universe where the door won't be opened. And the state feels that if Officer Fikes is questioned about the 2018 stop, then the state, to have the jury see a full picture of why Fikes is there, would be able to talk about everything he saw and did with that car, which goes into what we talked about yesterday, Your Honor.
Are you still not going to try and introduce the guns, right?
Your Honor, at this current time, the state was not intending to introduce anything with 2018 per your guidance.
Okay.
If Fikes discussed what he did, the state did have, and before the court's ruling yesterday, it's Exhibit X-ray. We had 5 photographs pertaining to the firearms, that the money and the marijuana that Officer Fikes and Officer Gant handled with that case. So the state would feel that if we're going to talk about it, if the door is opened, we would intend to introduce the photographs of those firearms. That is what Officer Fikes is testifying about and what he saw and witnessed.
The specific 2 things that I mentioned to the court have nothing to do with the contraband in the second vehicle.
Well, they do have, address this for me. He's got to be able to tell why it is it completes the picture in terms of why he was involved. He saw the weapons.
Not if he's talking about Jeffrey Williams' car and he's trying to get the Officer Gant to upgrade Jeffrey Williams' charges so they can search Jeffrey Williams.
That's a totally separate issue, and I agree that that goes to bias, separate issue. But the state's trying to tell me, or the state's trying to just have me rule upon is whether or not they get to complete the picture as to why Fikes is there to begin with.
Well, I mean, that's, first of all, the state has a little backwards. Gant makes a stop. Gant makes a request for additional officers to get to the location. Not just Fikes, a lot of other officers arrive at the location. And they're conducting their investigation. Gant is conducting the investigation in regards to the speeding ticket for Mr. Williams. The problem for them is that when Fikes comes up to talk to Gant, he's talking to him about Mr. Williams. When he asks him to mute his body camera, he's talking to him about Mr. Williams. When he asks him about upgrading charges, we're talking about Mr. Williams. We're not talking about, it doesn't matter why he's there. My analogy, I'm sorry. My analogy, let's say we had an issue about Officer Fikes' general credibility and bias in how he conducts investigations. And there was another case, a separate case, has nothing to do with it, where we have evidence that Officer Fikes has asked another officer to shut off their body cam, or has asked an officer to go ahead and upgrade charges on some defendants so that they could get in, they could search that defendant's car. That goes to that officer's credibility. Sure. It has nothing to do with this case. It has nothing to do with the reason that the person's there. It's just that officer's actions, right, that go to his credibility or his bias. And it shows obvious credibility and bias. I'm sure you can make that determination, but that doesn't open the door to allow them to talk about the second car, because we're not talking about it. We're talking about the second car or contraband that's found in the second car that has no connection or nexus to Mr. Williams.
Okay.
Your Honor.
I still agree, Mr. Atkins. I still agree that it's not relevant.
Your Honor, you agree with the state's position?
No, I agree with the defense's position.
Your Honor, may I respond?
Sure.
OCGA 24-8-822, and I'm going to prevents litigants from
24-8 what?
24-8-822, Your Honor, prevents litigants from misleading the jury by presenting portions of prior statements taken out of context, and it is often essential in order to arrive at the true drift, intent, and meaning of what was said on the previous occasion. And the reason that's so salient, Your Honor, is that
I didn't mean to actually click that. I was looking for the rubber band part. Hold on, we'll search for salient and we'll go back to where we left off. Hopefully he didn't say that multiple times. But yes, guys, this is the day with the rubber bands. Oh, it didn't get that? Litigant. There we go. Sorry about that. But yeah, this is the day where they end up presenting the rubber bands because they had taken like $40,000 in cash off of Jeffrey Williams and had to give the cash back. So they just brought the rubber bands.
Your Honor, prevents litigants from misleading the jury by presenting portions of prior statements taken out of context, and it is often essential in order to arrive at the true drift, intent, and meaning of what was said on the previous occasion. And the reason that's so salient, Your Honor, is that it's not just Officer Fikes being there, it's Officer Fikes. The information when he approaches Officer Gant is part and parcel of the firearm. So if he's crossed about, yes, Your Honor.
We covered this yesterday. It doesn't have a nexus. Stop trying to get into it. I'm still not convinced. So he shouldn't testify about why he was there. It's not relevant at this point in time because what it does is invites and opens the doors to the weapons. So you're not gonna do that at this time.
Yes, Your Honor. And
what they're trying to assert is they're examining just on bias. That's it. On the 18 stop.
Hear her?
I don't see another 18 stop. Examining just on bias. That's it. On the 18 stop. I don't see another reason at this point in time. I still have to. I understand what 24-8 does, 822 does, 822 does, but I'm still not convinced.
Understood, Your Honor. After cross-examination, the state will depending on how the testimony comes out, approach Your Honor before asking any questions related to that. If the state feels that the door has been opened.
Well, I'll be listening.
Yes, Your Honor.
Okay. All right, is Officer Fikes here?
Yes, Your Honor.
All right, let's go ahead and recall him, please.
All right, so put a 1 in the chat if you think that was all Atkins. Put a 2 in the chat if you think Love was pushing Atkins kind of as a surrogate to continue this argument. And I'm not saying Atkins didn't play a role, but I'm just saying I think Atkins wanted to let up on the gas. Personally, I think he wanted to let up on the gas yesterday already. So I think that's a fun way to, we just had this incredibly long marathon with one of Love's witnesses, Trontavious Stephens. I think that was a great way to break it up, where we kind of have Atkins standing in as a surrogate to argue for Adrian Love while she's coaching him from the bench, from her table. And oddly enough, Glanville actually yells at Atkins. And I'm not sure we would have had that enough. We argued about this yesterday. If it was actually Love arguing, I feel like Glanville would have let Love go on for like another hour about this, or conceded. Just my opinion based on past performance. Yeah, we have a ton of 2s going in the chat. Oh my goodness. So there we go. My conclusion is that was a surrogate argument on behalf of Love. Yeah, the angle of the neck just like stuck like this. The whispering. April O'Neil's baby daddy says this whole case is about the state misleading. Never mind. Yep. Lots of 2s, not a single 1. Good to see you, Plans and Pens. Guys, so we have a couple things. We're going to continue our Love-a-palooza. We have plenty more Love witnesses to get through. We are going to watch a little bit. There's like a 30-minute clip of the fruit of the poisonous tree arguments. Unfortunately, it's not the part that involves Love. But I do think it'll be worth watching maybe tomorrow's stream. Unfortunately, that stream seems to be like out, lost in the ether. I'll continue looking. Love ends up, once Judge Glanville wants to exclude the phone that was seized unlawfully from Jeffrey Williams, Love wants to continue arguing that. And I really wish we had that full pretrial hearing because it was awesome. Awesome, awesome, awesome. She got shut down. We're also going to look at, we've got some other witnesses to get to, but we will get to Miss Bennett. That's the witness where the detective, the investigator, was hitting on Miss Bennett. Miss Bennett said she felt uncomfortable by it. She didn't want to show up. They held her in contempt for not showing up under her subpoena. And Love was just crazy direct examining her. So we will get to that, but we've got some Love witnesses in between before we get to the time period where Bennett was on the stand. But I know everyone's looking for that. Yes. We're going to have all of that. No, that guy, Nick, that was pre-trial. So that was before I was streaming. I was just watching that. And the thing is, I swear I watched it with Law and Crime, not 11 Alive. But yeah, I don't know. But yeah, I mean, you guys know, you can picture it. It's going to be Love arguing that just because something was searched unlawfully doesn't mean it should be excluded. You're hamstringing the case. We should be allowed to present blah, blah, blah. Or we got leads from the stuff that was in that phone, but you shouldn't exclude that as fruit of the poisonous tree because we need that stuff. It was a day. It was a day. But yeah. So as far as other stuff, you guys, The Young Jerks I think The Young Jerks is where the court feed came from. They're the only ones I can find that have the court feed. For, you guys saw us talking in the chat, it's the Miles King case, but Prosecutor Adam Lally, who was part of the Karen Reed retrial, but he really did all of the questioning in trial 1. So most people remember him from Karen Reed trial 1. He's on the stand in another case, and Amber Dawn Them Johnson said there has been some drama. So if you want to check that out, that link is in the chat. We have it should be wrapping up, I think. We do have Millionaire Mel covering the cash out sentencing right now. And then we're going to have Flesh of the Gods, who is covering Keratin Matthews' closing statements tonight. And I had that open. Where did it go? So make sure you hit the notification for that. That's going to be at 7:45 p.m. Eastern. We'll call this one Fogs. And then you guys have heard me, especially when Tay Biz is in the chat, talk about the Shannon Sharp lawsuit. You've heard me talk a little bit about Tony Busby. I'm not sure all in all what Class C is going to talk about, but I do see Shannon Sharp and Tony Busby in the thumbnail, as well as the Astronomer CEO. So I think we're going to be talking about a civil suit settlement over in Class C morning show. And that's scheduled to start like right now. So we'll probably redirect there. So there's that in the chat. Yeah, that guy, Nick, I have a 1 o'clock on Mondays. Can't get out of it. So, and Melanie Little, I mean, she might be live, but I don't think she's covering Brooklyn. Is she still covering any? I think the hearing ended. So if she's live, she might just be doing like ratings of winding down her show. Okay, so she's still live. It looks like she's reading something. I don't know what though. So there's that. I'll set this to redirect over to the Astronomer CEO and Shannon Sharp drama, separate drama. Let's see. So there's that. And Chloe, I think Chloe popped in because she heard a Lally mention. Chloe, thank you for the 5, says, quote, just because he's got an alibi and someone else confessed doesn't mean we can't charge him with this murder. Yeah, that's Love's logic. That is Love's logic. And again, I mentioned in the chat earlier, Love had a case overturned because a conviction overturned. And one of the reasons was the prosecutor not only misrepresented something, but argued something that wasn't in evidence during closing statements to the jury. And the court found that to be improper. She ended up commenting on the defendant's pre-arrest silence, even though he spoke to police. So you're not supposed to comment on that anyway, but it was also untrue. And she argued it in closing, even though it wasn't in evidence and was just factually incorrect. So, you know, Love good memories there. Good memories. Okay, and Smart Towel, thank you, says Melanie Little is reading a motion from Karen Reed to remove travel restrictions. Okay, so that's what she's reading right now. Thank you for the context there. Definitely cannot tell on the screen. Thank you again to Chloe. Chloe came in. You know, I don't think our at this point in time counter is correct. Glanville said at this point many times without adding the in time to the end. So it was getting kind of tricky to count, but we're up to 7 full phrases. And I still think that that's short. For whatever you guys are planning to do today, hope everybody has a great day. Thanks for rewatching these reunions and hanging out again and seeing new details or seeing things in a new way, watching it with what we know now. I second what Max says. Max says, hope you have a good day. Right back at you and the whole chat. That guy Nick says, I have a ton of annoying calls today. So I'm going to save the Lally vid for a reward. I like the sound of that. I might do the same. And there we go. There we go, you guys. We're going to end this stream. We won't do an ABCs of Steel. We're going to end this one out because I've got to prepare for a call before our 1 o'clock coaching call in a few minutes. And tomorrow probably start around the same time, 9 in the morning Eastern. So see you then, you guys. Take care.